Good morning. Okay. All right, Mr. Young, can you hear me? And if so, could you start the recording? Great, thank you. Morning, ladies and gentlemen. Today is 4/2/2025's public hearing of the Board of Zoning Adjustment will please come to order. My name is Fred Hill, Chairman of the District of Columbia Board of Zoning Adjustment. Today, joining me are board members Kershawn Smith, Carl Blake, and zoning commissioners Gwendolyn Wright and Rob Miller. Today's meeting and hearing agenda are available on the Office of Zoning's website. Please be advised that this proceeding is being recorded by a court reporter and is also webcast live via WebEx and YouTube Live. The video of the webcast will be available on the Office of Zoning's website after today's hearing. Accordingly, everyone who is listening on WebEx or by telephone will be muted during the hearing. Also, please be advised that we do not take any public testimony at our decision meeting sessions. If you're experiencing difficulty accessing WebEx or with your telephone call-in, then please call our OZ hotline number at 202-727-5471. Once again, 202-727-5471. It's also listed on your screen to receive WebEx login or call-in instructions. At the conclusion of a decision meeting session, I shall, in consultation with the Office of Zoning, determine whether a full or summary order may be issued. A full order is required when the decision it contains is adverse to a party, including an affected ANC. A full order may also be needed if the board's decision differs from the Office of Planning's recommendation. Although the board favors the use of summary orders whenever possible, an applicant may not request the board to issue such an order. In today's hearing session, everyone who's listening on WebEx or by telephone will be muted during the hearing. And only person who has signed up to participate or testify will be unmuted at the appropriate time. Please state your name and home address before providing oral testimony or your presentation. Oral presentation should be limited to a summary of your most important points. When you're finished speaking, please mute your audio so that your microphone is no longer picking up sound or background noise. All persons planning to testify either in favor or in opposition should have signed up in advance. They'll be called by name to testify. If this is an appeal, only parties are allowed to testify. By signing up to testify, all participants complete the oath or affirmation as required by subtitle Y408.7. Requests to enter evidence at the time of an online virtual hearing, such as written testimony or additional supporting documents, other than live video, which may not be presented as part of the testimony, may be allowed pursuant to Y103.13, provided that the person making the request to enter an exhibit explain A, how the proposed exhibit is irrelevant, B, the good cause that justifies allowing the exhibit into the record, including an explanation of why the requester did not file the exhibit prior to the hearing pursuant to Y206, and C, how the proposed exhibit would not unreasonably prejudice any parties. The order of procedures for special acceptance and variances are in subtitle Y409. Excuse me. At the conclusion of each case, an individual who is unable to testify because of technical issues may file a request for leave to file a written version of the planned testimony to the record within 24 hours following the conclusion of public testimony in the hearing. If additional written testimony is accepted, then parties will be allowed a reasonable time to respond as determined by the board. The board will then make its decision at its next meeting session, but no earlier than 48 hours after the hearing. Excuse me, I'm sorry. Moreover, the board may request additional specific information to complete the record. The board and staff will specify at the end of each hearing what is expected and the date when persons must submit the evidence to the Office of Zoning. No other information shall be accepted by the board. Finally, the District of Columbia Administrators Procedures Act requires that. Finally, the District of Columbia Administrators Procedures Act requires that the public hearing on each case be held in the open before the public. However, pursuant to Section 405B and 406 of that Act, the board may, consistent with its rules of procedures and the Act, enter into closed meeting on a case for purposes of seeking legal counsel on a case pursuant to DC Official Code Section 2-575B4 and or deliberate on a case pursuant to DC Official Code Section 2-575B13, but only after providing the necessary public notice in the case of emergency closed meeting after taking a roll call vote. Madam Secretary, do we have any preliminary matters?
Good morning, Mr. Chairman, members of the board. There are no changes to the schedule today. However, regarding late filings, the chairman has reviewed and granted waivers to allow late filings into the applicable case record pursuant to Subtitle Y, Section 206.7 and Section 103.13, Any other late filings during the course of today's live hearing should be presented before the board by the applicant, parties, or the witnesses after the case is called. Any other preliminary matters will be noted when the case is called.
Okay, thank you. Okay, good morning, everybody. I think Commissioner Wright, we have Commissioner Miller first on first decision, and then we'll see right after that. Commissioner Miller, welcome. And Madam Secretary, you can call our first issue of business.
The first case in the board's meeting session is application number 21239 of John Heyman. This is an application pursuant to Subtitle X, Section 901.2 for special exceptions under Subtitle D, Section 5201, from the side yard requirements of Subtitle D, Section 208.7, and from the lot occupancy requirements of Subtitle D, Section 210.1. This is for a two-story rear addition to an existing two-story detached principal dwelling. It's located in the R2 zone at 3220 Brothers Place Southeast, square 5990, lot 12. This was heard on February 5th and February 26th. The decision that was scheduled for March 12th was postponed at the request of the ANC SMD 8C04, and submissions were requested from the applicant. And participating are Chairman Hill, Vice Chair Blake, Mr. Smith, and Commissioner Miller.
Okay, thanks, everybody. All right, so this went on for quite some time in terms of the hearing. We heard or took a lot of testimony from the ANC, members of the community, the party, the neighbor in opposition, and we asked for some additional information and also gave more time for the ANC to again review this after we got more updated numbers in terms of what exactly was there and being proposed and being built. So I went back and took a look at the Office of Planning's report, as well as the supplemental report, as well as the ANC and the ANC's supplemental report, all of which were in favor of this particular request. I went then back and looked at D 5201.4 and all the different criteria within there, as well as X 901.2, which were the standard that we're supposed to take a look at to determine whether or not this is something that should be granted by special exception. I think that in my particular case, I don't think that the addition is necessarily going to cause any more undue impact than what was really there actually, and kind of what I had easier time taking a look at is some of the additional material that came forward in terms of the plat and some of the photographs, as well as, again, as I mentioned, the continued support of the ANC. But the addition basically is, again, it's another, what is it? 9.4 inches, I think, from what was originally there. And even what was originally there did tend to block some light to that neighbor. But I don't think the addition, it's going back on the same line as what is there in terms of the building itself. Now, I suppose that this could have been done easier for the applicant had they just done the 5 feet on either side, but that might have made, something really not worthwhile, I suppose, for that additional 9 feet 4 inches. So taking a look at the material that's been put forth since the hearings have gone forward, I am comfortable granting this application, given the criteria that we're supposed to look at. May I go to Mr. Blake next?
Sure. Thank you very much. I agree with the comments that you made. We first debated this application in February, on February 26th, actually. And when we deliberated then, I was in support then, and I remain in support of the application today. I continue to believe that the applicant has met the burden of proof to be granted the requested relief. The issue that came to my attention is this, and what to me was the issue. The measurements have been inaccurate from the outset. The measurements provided to the Department of Buildings were inaccurate, just as the measurements provided to at the outset of this hearing were inaccurate. As a result, the work exceeded the scope of what was approved by the DOB and its permits, and the application took a very long time to weed through, and it didn't necessarily have to. So I just was, the issue at the end to me was we got to get measurements right and, focus on this thing properly. That said, the project is where it is. I do think it met the criteria for approval, and I will be in support of the application.
Thank you, Mr. Blake. Mr. Smith, could I go to you next?
I have nothing to add, Chairman Hill. I agree with your assessments, you and the Vice Chair's assessments on this particular case. I do not believe that, and we've debated this back and forth, and we've given the ANC an additional opportunity to take a look at this this particular application, and that was the reason why we kicked it. And given that they've taken a look at this application, gone through it again with another fine-tooth comb, with the additional information that was provided at the previous hearings, I'm comfortable with moving forward with this application as well, and believe it will not have a substantial undue hardship on any of the surrounding properties. So with that, I will support the application.
Thank you. Commissioner Miller?
Thank you, Mr. Chairman, and I agree with your comments, Mr. Chairman. Your very thorough analysis, as well as Vice Chair Blake's and Board Member Smith's comments. I think with all of the supplemental information, the accurate numbers of what was being proposed and what was there, the additional the opportunity for the ANC to review this with the right numbers for the side yard, and the aerial photograph that we got of showing the context of the neighborhood, and what's been there for a while, and the petition that was submitted from, I think it was over 20 neighbors in support as well. So I've reached a comfort level for this relief and ready to move forward, and I appreciate all the time that everybody has taken on this case. Thank you.
Thank you, Commissioner. All right, I'm going to make a motion to approve application number 21239 as captioned read by the Secretary, and ask for a second, Mr. Blake.
Second.
Motion been made and seconded, Madam Secretary, if you can take a roll call.
Please respond to the chair's motion to approve the application. Chairman Hill,
Yes.
Vice Chair Blake,
Yes.
Mr. Smith,
Yes.
Commissioner Miller.
Yes.
Staff will report the vote is 4-0 to 1 to approve application 21239 on the motion made by Chairman Hill and seconded by Vice Chair Blake.
Great, thank you. Commissioner Miller, is that it for you today?
Fortunately, that is it for me today. So I hope you have a great day.
Thank you. Have a nice day as well.
Thanks.
Thank you. All right, Commissioner Wright, welcome back. Okay, I think, yeah, that's right. Okay. I think, Madam Secretary, you're going to call 21231, correct?
I can call that one next. I think I wasn't sure if we were doing the time extension or the decision.
Let's do that one now, because I pulled it all up. I got a little out of whack, I guess.
Which one? The
21231.
next in the board's meeting session is appeal number 21231 of Courtney Bolin and William Gabler. This is the appeal of the decision made on August 23rd, 2024 by the Department of Building Zoning Administrator to issue building permit number B2309496 pursuant to subtitle X, section 1100. This is appealing a new 2-story accessory structure containing an accessory apartment located in the R1B zone at 3021 15th Street Northeast, square 4017, lot 22. This was heard on March 12th and scheduled for decision. Participating are Chairman Hill, Vice Chair Blake, Mr. Smith, and Commissioner Wright. And as a preliminary matter, there is a motion filed by the appellants to reopen the record in Exhibit 25.
Okay, thank you. Okay, so let's talk about this request to reopen the record. So, all right. So I don't necessarily agree that the appellant did not have enough time to respond during the hearing. or that new information was necessarily provided beyond what normally occurs during the course of a normal hearing, meaning there's a testimony, then there's response to the testimony. However, out of an abundance of caution, I suggest that we go ahead and reopen the record and allow the file into the record from the appellant. I then think that we should give, and there is opposition to the motion to reopen the record from both the Department of Buildings and the property owner. And I think that the motions actually that they filed were also made sense to me. But I think that, again, since this seems to be a more litigious case than we had, not always have, but in this particular case, it could become litigious, that I think that, again, out of abundance of caution, we'll go ahead and let the appellant put into the record what they wanted to put into the record, allow the parties to have 7 days to respond, and then we can come back here again to deliberate. Now, again, I don't know where we all might end up, but again, those are my thoughts in terms of the motion to reopen the record. And I'm going to go around the table. Mr. Smith, what do you think?
I agree with your assessment that I don't think it does any harm to add the additional information into the record for us to deliberate on potentially in the future. But I'm in support. I'm in support of adding it.
Okay, great. Vice Chair Blake?
Yes, Mr. I'm in support of omitting the additional information with the caveat that the appellee and owner have the opportunity to respond. And I think you can agree with that.
Sorry, thanks. And that also brings up another point that this will be the last round. Like, we're not going to go back and forth on this, right? We're going to admit this into the record. The parties will have an opportunity to respond, and then there will not be a response to the response. Like, this is all we're going to do here in terms of, I mean, again, it was a 4-hour hearing. So we had a lot of testimony, and there's a lot of information in terms of what I think the board needs to make a decision. Thank you for that comment, Mr. Blake. Commissioner Wright?
I agree with reopening the record to let the appealee's submission in. And I think it's important to have a conversation about the points that they've raised.
Okay, all right, great. All right, Madam Secretary, so if we do that, what am I going to do here? When can we get back here?
So you could give a week for the parties to respond. We'll put in the record today. They could have until the 9th to respond. And then you could come back on the 23rd for a decision, because there's no hearing on the 16th.
Right, we're off on the 16th. Okay, that's fine. Let's do that. Who's with us on the 23rd? Or Commissioner Wright's not. Commissioner Wright, are you available on the 23rd?
I am available on the 23rd. Yes.
Okay, great. And we'll go ahead and do this first, Commissioner Wright, also, so you can then go on with your day. Okay, let's do that then. So we're moving the decision to okay. Go ahead, Madam Secretary.
No, so just to clarify, so any response due by April 9th, and no responses to the responses will be accepted.
Exactly. Hey, do me a favor. I don't think it. Can you give them till the 10th to respond?
Yep.
Okay. So give them till the 10th to respond, because today, Wednesday. That means. All right. Okay, that's it. We can move on to our next order of business, which I do think is the time extension.
The next case or the last case in the board's meeting session is application number 20554A of Sasha Bruce Youth Work. This is a request pursuant to Subtitle Y, Section 705.2 for a 6-month time extension of the validity of the order in application number 20554. This is for a youth residential care home for up to 15 persons in an existing 3-story building. It's located in the RF1 zone at 1022 Maryland Avenue Northeast, square 961, lot 803.
Okay, thank you. I don't know why I'm having a hard time pulling up this particular file. Let me try again, please. Okay, great, thanks. All right, so I didn't particularly have any issues with the extension. I mean, I think that they're still waiting for some, I guess, a C of O from DOB. However, I do cite the Office of Planning's report, as well as that the ANC didn't have any issues with the extension. What I would propose, though, is 6 months seems just like kind of an odd extension. And so I propose we go ahead and give them a year, which would take them out to 12/19/2025, basically the end of this year. And even in the Office of Planning's report, I guess they cited 2 years extension, but I think they just meant also the 6-month. But I don't have any issues with the time extension. Mr. Smith, do you have any thoughts?
No, I agree with your assessment and the recommendation to do 1 year because six months seems very odd. And that's really only giving them 2 months. So I'm in support of the 1 year extension.
Thank you. Vice Chair Blake?
I agree, Mr. Chair. I think a 1 year extension is appropriate. It's unclear to me exactly what the issues are with the issuance of the C of O. And because I don't have an idea of what that might be, I have no idea what the way they described it is just a difficulty getting through the process. So I think that a year is appropriate just to be on the safe side, to more efficient for the board and so forth.
Thank you. Commissioner Wright?
Yes, I agree to a 1 year extension as well.
Thank you. All right, I'm gonna make a motion to approve the time extension of 20554A as captioned read by the secretary and ask for a second, Mr. Blake.
Second.
Thank you. Just to be clear again, this was for a 1 year time extension to get to 12/19/2025. Madam Secretary, if you take a roll call.
Please respond to the chair's motion to approve the time extension, the 1 year time extension. Chairman Hill,
Yes.
Vice Chair Blake,
Yes.
Mr. Smith,
Yes.
Commissioner Wright.
Yes.
Staff would report the vote is 4-0 to 1 to approve the time extension 20554A on the motion made by Chairman Hill and seconded by Vice Chair Blake.
Thank you. You guys, could you give me like 3 minutes? I just have to get something organized. I'll be right back. All right, I think we're all going to be here long enough that we're going to have lunch. So we should all start thinking about what we're going to have for lunch. Okay, Madam Secretary, can you hear me?
Yes.
I think there was some, so what I think I would like to do is do a couple of preliminary matter items on 2 cases. And then depending on how that goes, we might hear those cases at the end of the day. So go ahead, Madam Secretary, and call our first preliminary or whatever you want to call.
So first is party status request for application number 21262 of Ian Packman and Ellen Carlson. This is a self-certified application pursuant to Subtitle X, Section 901.2 for special exceptions under Subtitle D, Section 5201. From the requirements for a rear yard under Subtitle D, from Subtitle D, Section 207.1, and lot occupancy from Subtitle D, Section 210.1 from the lot occupancy requirements. This is for a 2-story rear addition to an existing 2-story attached principal dwelling. Project is located in the R3/GT zone at 2728 O Street Northwest, square 1239, lot 854. And the 2 requests for party status in opposition are from Brew LaRocca of 1363 28th Street and April Lynn Bowler and Jamie Peva, who are the owners of 1359 28th Street.
Okay, so we're not bringing anybody in. Is that correct, Madam Secretary?
You don't have to, but they are present if needed.
That's great. That's fine. So, so they're obviously listening, I would assume. So what I would propose we do is, and by the way, the Office of Zoning, you guys, thank you so much for the maps. The maps and where the location is of people that are requesting party status is so helpful in terms of what we had been doing in the past. This is very helpful. So seeing the locations of the 2 people that are in opposition or the 2 parties that are requesting party status in opposition, I think they do meet the criteria for us to grant the party status. And what I had hoped for as they're listening is that explaining how it works. So if they were to get party status, which we'll see if that happens, then the applicant comes forward, the applicant gives their presentation. Then the party status people will also have the same, in this particular case, since there's only 2 party status people, basically, groups of people, they will both have the same amount of time as the applicant to give their presentation. There will then be questions from the board, there will be questions from the applicant, there will be questions from the party status people of each other. Then there is the Office of Planning. We'll hear from them. Everyone will get a chance to ask questions of the Office of Planning. There will be a rebuttal by the applicant of anything that has gone on through the hearing. And then the party status people or all parties will get an opportunity to ask questions just on the rebuttal, not to start the conversation again, but just on the rebuttal. Then this part is not in the regulations, but basically then we'll have a conclusion from the 2 party status people, as well as then a conclusion from the applicant, and then we'll move on with our day. So I don't think you all have any questions about anything. My only question is whether or not you agree with the party status issue, and I'll turn to Mr. Smith. And if you have any comments on anything I said, I guess, but Mr. Smith?
No, I agree with your assessment on this. The 2 status requesters are directly adjacent to the subject property and would be directly impacted by any changes that would occur with the addition as relates to light and air and privacy to their properties. So I am in support of granting them party status for this particular case.
Thank you. Mr. Blake?
I agree. I have nothing to add.
Thank you. Commissioner Wright?
I agree to adding the 2 property owners as parties.
Okay, great. Thank you. All right, then, Madam Secretary, we'll go ahead and grant party status to the two groups, I guess, that have requested party status, and then we'll come back and have their case at the end of the day. I think there's also going to be another case at the end of the day. This will be the first of the two cases at the end of the day. Madam Secretary, do you have anything for us?
No, nothing else.
Okay, great. Then let's move on to our next preliminary matter, please.
The next request for party status is an application number 21263 of Susan M. Tamburini, trustee. This is a self-certified application pursuant to Subtitle X, Section 901.2, for special exceptions under Subtitle D, Section 5201 from the lot occupancy requirements of Subtitle D, Section 210.1, the building area requirements of Subtitle D, Section 5003.1 to allow an accessory building with a building area greater than 450 square feet, and the accessory building location requirements of Subtitle D, Section 5004.1A to allow an accessory building in a required rear yard. This is for a new accessory structure in the rear yard of an existing two-story detached principal dwelling located in the R1B zone at 4632 Charleston Terrace Northwest, square 1368, lot 54. And there is a request for party status in opposition from Deborah James, who owns 4634 Charleston Terrace.
Great, thank you. So again, I neglected to mention this on the other one, but I do think they know. The ANC is also a party, so the ANC might be involved in that other case that we just went through. So again, this issue before us is party status for an adjacent property that I do think also meets the criteria for us to grant party status. So if party status were to pass, I'm going to repeat myself, whether they were watching the first time or not, the applicant will give the presentation. The party status person will have the same amount of time as the applicant to give their presentation. The Office of Planning will give their presentation. There will be questions from the party status and opposition to the applicant, from the applicant to the party status and opposition, if anybody has any questions. There will be rebuttal done by the applicant. The questions will then take place from the party status and opposition, as well as the board. Is anything on rebuttal? We're not rehashing the case, it's just on the rebuttal. There will then be a conclusion from the party status people in opposition, as well as the applicant, and then we will continue to move forward. And at any point, the board or the board will have questions, can do that from also the Office of Planning, et cetera. Mr. Smith, do you have anything you'd like to add?
I have nothing to add. I'm in support.
Mr. Blake?
I'm in support, Mr. Chair.
Commissioner Wright?
I also support the party status request.
Thank you. All right. I think, Madam Secretary, as I mentioned before, we'll do this. This will then be at the end of the day. We're going to do 21262 and then 21263. And I don't know, before I continue, do you have anything to add, Madam Secretary? No. Okay. Okay. Then I think maybe we might start 21262 before lunch. Just to give everybody a little bit of time as to where I think things might fall. And probably 21263 would not happen until after lunch. But yeah, that's kind of just to give everybody kind of an idea. And then, Madam Secretary, you can call our next order of business.
So the next case in the board's hearing session is application number 21253 of the owner of 1232 Maryland Ave Northeast. This is a self-certified application pursuant to Subtitle X, Section 901.2 for special exceptions under Subtitle E, Section 207.5 to allow the rear wall of a row dwelling to extend farther than 10 feet beyond the farthest rear wall of any adjoining principal residential building on any adjacent property, and under Subtitle E, Section 5201 from the lot occupancy requirements of Subtitle E, Section 210.1. This is for a two-story rear addition to an attached two-story principal dwelling located in the RF1 zone at 1232 Maryland Ave Northeast, square 1005, lot 64.
Thank you. If the applicant could hear me, if they could please introduce themselves for the record.
Hi, everyone. This is Jennifer Fowler. I'm the architect representing the homeowners.
Okay, thanks, Ms. Fowler. Ms. Fowler, do you guys do any matter of right work?
Actually, I do a bit of that too.
Okay, all right. Okay, Ms. Fowler, if you could please walk us through your client's application and why you believe they're meeting the criteria for us to grant this relief. I'm going to put 15 minutes on the clock so I know where we are, and you can begin whenever you like.
Okay, thank you so much for your time. This is a request for lot occupancy over 60%. We're asking for 70% coverage. The existing house is 57.9%, which includes a deck that's about 10 feet above the grade at the rear. We're also asking for the rear yard setback. We're extending 20 feet 1 inches beyond 1234 Maryland Avenue, but only 7 foot 6 inches beyond 1230 Maryland Avenue. It's a 2-story rear addition. It's the same height as the existing house. The rear of the house does have a walkout basement, so it's about 30 feet tall at the rear, but we're keeping the same roof line as above. And on the second floor, there's a dog leg, a setback against 1234 to allow for windows, and we've included a high window on there for privacy purposes. There is a Sun study in the record that compares the matter of right version, which would be 6.78 foot deep addition, to the proposed addition, and that shows that there is minimal impact to the neighboring properties due to the orientation of the lots. We do have ANC support as well as letters of support from both of the adjacent neighbors. And we've received support from Office of Planning. So with that, I will leave it open to questions. Thank you.
Okay, great. Thank you. Before I turn to my board from questions, could I hear from the Office of Planning, please?
Good morning, Crystal Myers for the Office of Planning. The Office of Planning is in support of this case and can stand on the record of the staff report. Of course, here's for questions. Thank you.
Thank you. All right. Does the board have any questions for the applicant or the Office of Planning? Go ahead, Mr. Blake.
I have one question. There is one party, I believe, in opposition, and the issue focuses on the shadow studies indicating that it may understate the impact. Could you address that for me, Ms. Fowler?
I apologize. I wasn't aware of any opposition letters.
I think Mr. Blake's talking about CHRS.
Oh, the CHRS. I went and presented to the CHRS and went over the Sun study and showed that if you look at the Sun study, you can see in red where I've dotted in where the changes from the matter of right to the proposed. And it primarily falls in very small parts of the rear yards of the properties. And there was really no impact to people's windows, sunlight kind of entering the houses. So in my opinion, it was not an undue impact. And they probably just have a different viewpoint on that. But I think the Sun study shows it's definitely within the realm of what's normally approved and accepted by your board. Thank you.
Thank you.
Thank you, Ms. Fowler. Anyone else? Okay, Mr. Young, is there anyone here wishing to speak?
We do not.
Okay. All right, Ms. Fowler, you have anything at the end?
No, I don't. Thank you so much for your time.
Thank you. All right, I'm going to go ahead and close the hearing on the record. If you could please excuse everyone, Mr. Young. I didn't have any issues with this particular case. I thought that it meets the criteria for us to grant the relief. It is helpful that both adjoining neighbors are in support. It's not necessary, but it's helpful. Also, it's nice to see that the ANC is in support, and I do appreciate the analysis that the Office of Planning has provided. I will agree with the analysis the Office of Planning has provided. And in terms of the shadow study, it looks to me as though most of it is falling onto existing garages. So I don't think that the additional shadowing from what is a matter of right option is necessarily anything that's undue that would keep me from voting for this case. I'm going to be voting in favor. Mr. Smith, do you have anything you'd like to add?
I have nothing to add, Chairman Hill. I agree with your assessment of this case as well as the Office of Planning's assessment of this particular of the requested relief, and will support the application.
Thank you. I'd also appreciate that the applicant has worked with the architect in making a window higher, so there's no a privacy issue. Mr. Blake, do you have anything else? Do you have anything else you'd like to add?
I do not, Mr. Chair. I'm in support of the application. I believe the applicant has met the criteria for approval.
Thank you. Commissioner Wright?
No comments. I support the application.
Thank you. All right, I'll make a motion to approve application number 21253 as captioned and read by the secretary and ask for a second, Mr. Blake.
Second.
Motion made and seconded, Madam Secretary. Take a roll call, please.
Please respond to the chair's motion to approve the application. Chairman Hill,
Yes.
Vice Chair Blake,
Yes.
Mr. Smith,
Yes.
Commissioner Wright.
Yes.
Staff would report the vote as 4-0 to 1 to approve application 21253 on the motion made by Chairman Hill and seconded by Vice Chair Blake.
Thank you. You may call our next item of business when you have an opportunity, Madam Secretary.
Next is application number 21194 of Karen Marsh. As amended, this is a self-certified application pursuant to Subtitle X, Section 901.2 for a special exception under Subtitle F, Section 5201 from the rear yard requirements of Subtitle F, Section 207.1 and pursuant to Subtitle X, Section 1001 for area variances from the floor area ratio requirements of Subtitle F, Section 201.1 and the lot occupancy requirements of Subtitle F, Section 210.1. This is for a rear addition, including a 60 square foot upper level stair enclosure and elevated egress stair walkway in the required rear yard of an existing attached principal dwelling for use as a 2-unit building. It's located in the RA2 zone at 1837 Vernon Street Northwest, square 2555, lot 36. The hearing was originally scheduled for November 13th, 2024, and was postponed twice at the applicant's request. As a preliminary matter, there's also a motion to waive the filing deadline to allow an updated self-certification form, which is in the record in Exhibit 41A.
Okay, thank you. I don't have any issues letting in the updated self-cert. I think it's necessary for the board to understand what's going on. Unless my fellow board members have any issues, please raise your hand or speak up. Hearing none, we'll go ahead and allow that into the record. If the applicant could hear me, if they could please introduce themselves for the record.
Yes, good morning, Chairman Hill and members of the board. For the record, Elizabeth Rogers with the law firm of Lurch, Early and Brewer, here today on behalf of the applicant, Karen Marsh. With me also is Karen Marsh, the applicant, and CJ Lamore with Circle Square Cross, the applicant's architect.
Okay, great. Thank you, Ms. Rogers. I'm just going to go around also. Could the architect please introduce himself?
Good morning, board. My name is Christopher Lamore. You can call me CJ. I am the principal architect of Circle Square Cross Architecture, and we've been working with Miss Marsh on this for a while now.
Okay, thank you. Ms. Marsh, would you like to introduce yourself for the record?
Hello, my name is Karen Marsh, and I have been a resident of DC at 1837 Vernon Street for 32 years now.
Well, very good. Okay. Ms. Rogers, you may go ahead and walk us through your client's application and again, why you believe they're meeting the criteria for us to grant the relief. I'm going to put 15 minutes on the clock so I know where we are and you can begin whenever you like.
Great, thank you. And we put together a PowerPoint presentation, Mr. Young. If you can please pull that up, it's Exhibit 45. Perfect, thank you. We are requesting both special exception and variance relief. The special exception seeks relief from the rear yard requirements, and the variance seeks relief for the lot occupancy and FAR allowances of the zone. The requested relief is necessary to permit the creation of an upper level apartment on the 4th floor of the existing row building, consistent with the intent of the residential apartment zone and the property's historic use of a group home. Specifically, the rear yard relief and the lot occupancy is needed to allow for the construction of an elevated egress stair and walkway, which will connect the alley to the 3rd floor. And the FAR variance is necessary to allow for the construction of a very minor 64 square foot addition to the upper level to accommodate an interior access stair and the necessary headroom associated with it. Next slide, please. The property is located along Vernon Street Northwest, approximately equidistant between 19th Street and 18th Street. It's currently improved with a 4-story road dwelling containing approximately 3,800 square feet that was built circa 1899. Next slide, please. The property is located in the RA2 zoning district. It's also within the Washington Heights Historic District. Next slide, please. The property is unique in that it was actually previously occupied as a group home for approximately 30 years, from the 1970s until 2006. As a result, the upper level of this building is uniquely situated for conversion into an apartment unit, as it already has the infrastructure, both plumbing and electrical, to support a separate kitchen and bathroom. You can see that area where there's currently kind of the kitchen and bathroom on the upper level today, shown in yellow on the top right-hand corner of the image. The applicant, as Ms. Marsh mentioned, has resided in this house for over 30 years and desires to remain. But this large historic home is much bigger than the applicant's family currently needs. So she'd like to create an upper level apartment on that 4th floor to provide for necessary additional housing to increase the diversity of housing within this desirable neighborhood. However, to do so, she needs to construct dedicated, separate egress and access for life safety purposes to that unit. Next slide, please. Given the interior configuration of the existing building, in order to accommodate that egress and access, the applicant must construct an exterior stair and walkway, which would provide access from the alley through the garage up to the 3rd floor of the existing home. That exterior stair and walkway is shown on the slide in yellow. And this is what's triggering the lot occupancy, or a portion of this is triggering the lot occupancy and rear yard relief. Next slide, please. And then on the interior, the applicant must construct a separate dedicated interior access stair, which will provide that access from the 3rd floor up to the 4th floor. As you can see here, most of that stairwell actually can be accommodated within the existing building envelope. It's actually just the portion up on the 4th floor where we need to construct that modest 64 square foot addition to accommodate the necessary head height for the stairs and that landing. If you go to the next slide, you can kind of see thank you. That is the 64 square feet from the exterior that would be constructed. Everything else is accommodated within the existing building. Next slide, please. The access and egress modifications are shown here in plan view, both in yellow on the 3rd floor and then in orange on the 4th floor plan view. These are the only modifications that are being proposed, which are triggering the need for this relief. I would just note this project has been a long time in the making. The applicant actually originally received building permit approval in 2021, but didn't move forward with construction before those permits expired. And it wasn't until the applicant went back in to seek new permit approval that the need for this relief was identified. As detailed in our burden of proof statement and pre-hearing statement, the proposed application satisfies the various findings the board must make to approve the variance and special exception. Given the detail that's provided in the record, I'll be brief in my summary of those, but happy to provide any additional detail the board would like. In terms of the special exception, this application is in harmony with the general purpose and intent of the zone and the zoning map, including the specific purpose and intent of the RA2 zone. The residential apartment zones are designed to provide areas suitable for multiple dwelling units. And the RA2 zone itself provides for areas developed with predominantly moderate density residential and permits multiple units on this property. The residential use on the property will remain unchanged. The applicant's merely seeking to construct an upper level apartment within the existing building, which is in keeping with the intent of the zone and obviously the historic use of the property, which has housed multiple DC residents for over 30 years when it was used as a group home. As such, the proposed modifications are fully consistent with the purpose and intent of the RA2 zone, but additionally the comprehensive plan, which recognizes the importance of housing diversity, including a mix of units, sizes, and also opportunities for both rental and home ownership in this area of the city. The proposed special exception will not tend to adversely affect the neighboring properties. You can go to the next slide. Thank you. The light and air available to neighboring properties won't be unduly affected. The proposed elevated stair and walkway will be constructed of steel framing that has an open design to allow light and air to permeate through it. As such, it will only cast very minor additional shadows on the adjacent properties, and no outdoor living space will be created by that proposed elevated stair and walkway. Importantly, these improvements are actually similar to the conditions that exist on both the adjacent property and some of the properties across the alley. As you can see here in the upper right-hand corner is the immediately adjacent property, which kind of has an elevated exterior stair and landing. And you can see across the alley, there's obviously for those apartment units, several similar kind of stair access conditions. Next slide, please. In terms of the variance findings, the extraordinary situation and conditions arise from a confluence of factors and the zoning history of this project. Here, the exceptional situation conditions includes the existence of a row building constructed circa 1899, now located in a historic district, which was previously occupied as a group home for approximately 30 years. Given the prior use of the property as a group home, as I mentioned, the plumbing and electrical is already there on the 4th floor to accommodate this apartment unit. In order to utilize that, however, the applicant must construct these improvements to provide for that necessary access and egress. That additional unit, though, will be fully consistent with the intent of the RA2 zone. The strict application of the zoning ordinance would result in peculiar and exceptional practical difficulties on the applicant. The board has flexibility, obviously, to consider a number of factors when making that finding, including the increased expense and inconvenience, the severity of the requested variance, and the effect that the variance would have on the overall zone plan. Here, the property is already non-conforming with respect to FAR and lot occupancy. Therefore, any additional modification to the structure would trigger the need for relief. Based on the prior use of the existing building as a group home, as I mentioned, it's already built out to accommodate that apartment unit. To locate that apartment unit elsewhere within the building would require significant expense and modifications and substantial additional cost. Importantly, the relief that we're requesting is de minimis. It's only 64 square feet of additional floor area to accommodate the headroom and the landing for that interior stair, and 60.8 feet of additional coverage for that exterior stair and walkway, which would increase the lot occupancy by 3.51%. This relief can be granted without substantial detriment to the public good or impairing the intent or purpose of the zone plan. The upper floor apartment that we're proposing is consistent with the purpose and intent of the RA zones. It also adds housing diversity in this desirable neighborhood, which promotes the goals of the comp plan. It'll be continued to be used for residential use, which is of course in keeping with the character of the surrounding neighborhood, and it will importantly promote a public policy objective of increasing housing supply within the city. We are pleased that the agency voted unanimously to support. To support the special exception and variance application. Their support is in the record at Exhibit 37. We went back to them when we added the variance relief, and they reaffirmed their support. The immediately adjacent neighbors have also expressed their support for the proposed application. And for all these reasons, we believe that the board can make the necessary findings to improve their special exception and variance relief, and be happy to answer questions you may have. And Karen, I just wanted to make sure, was there something you were trying to add? No? Okay.
No, I'm here for questions. Yes.
Great. Thank you.
Okay, thank you, Ms. Rogers. All right, before I turn to the board, could I hear from the Office of Planning?
Thank you, Mr. Chairman and members of the board. My name is Matt Jessic, presenting OP's testimony in this case. And the Office of Planning is happy to rest on the record in support of the application, but I'm available for any questions. Thank you.
Thank you. Thank you, Mr. Jessic. Does the board have any questions for the applicant or the Office of Planning? Go ahead, Commissioner Wright.
Hi, Ms. Rogers. Nice to see you. I just wanted clarification. The bedroom on the 3rd floor that's noted on the architectural plans, is that associated with this apartment unit, or is it part of the main house and it's just being shown as a bedroom to identify its use?
It is shown just as a bedroom to identify its use. It'll continue to be part of the main dwelling. It's just that bedroom has to actually be modified and kind of shrunk to accommodate that interior access stair, which is why it's called out. But it won't be part of the upper level apartment.
Great. And the other question is the staircase that goes to touch the ground does it go next to the garage or through the garage?
It'll actually go through the garage. So the garage will be opened up to accommodate that stairwell that will then provide access to the alley grade.
Great, thank you. Those were my only questions, just for clarification.
Thank you, Commissioner. Anyone else? Okay, Mr. Young, is there anyone here wishing to provide testimony?
We do not.
Okay, all right, Ms. Rogers, do you have anything you'd like to add at the end?
Nothing further. Thank you.
Okay, thank you. I'm going to go ahead and close the hearing and the record. Mr. Young, if you could please excuse everyone. Okay, thank you. I appreciate the architectural drawings were a little bit complicated for me, and so I appreciate some of the questions. That makes it more interesting, I suppose. But also, I think that they are meeting the criteria for us to grant this relief. The one that I wanted to kind of spend more time on was again the variance relief, and I think that they have demonstrated again from the confluence of factors how they're meeting the uniqueness of the property, and how I do think that the 64 square feet is de minimis in terms of how this is triggering the relief. And I do think that this being an area variance, they are showing a practical difficulty to the owner, also given that there is plumbing and electrical on that top floor. And so I will be voting. Oh, and also I do cite that the Office of Planning's report, and I do appreciate the analysis that they have provided, and also that of the ANC. And it is nice that they have worked with their neighbors in terms of providing enough information as to this project and received their support. I will be voting in favor of this application. Mr. Smith, do you have anything you'd like to add?
No, Chairman Hill, I agree with your assessment and your description of this particular case and how they met the burden of proof for us to grant the special exception and the area variances, given the confluence of factors related to the design of the existing design and utility layouts in the existing building. I'm inclined to grant them the area variances and the special exception for this very unique design that they're proposing to construct these series of stairs. So again, I'm in support.
Thank you. Vice Chair Blake?
Mr. Chair, I am in support of the application. I agree with the analysis you put forth, as well as Mr. Smith, and I have nothing I want to add.
Thank you. Commissioner Wright?
I also support the application and agree with the comments of my colleagues.
Thank you. All right, I'm going to make a motion to approve application number 21194 as captioned read by the secretary, and ask for a second, Mr. Blake.
Second.
Motion made and seconded, Madam Secretary. Take a roll call, please.
Respond to the chair's motion to approve the application. Chairman Hill,
Yes.
Vice Chair Blake,
Yes.
Mr. Smith,
Yes.
Commissioner Wright.
Yes.
Staff would record the vote as 4-0 to 1 to approve application 21194 on the motion made by Chairman Hill and seconded by Vice Chair Blake.
Okay, great. If it's okay with you guys, can we just take a 15-minute break? We'll come back. Let's try to come back at 11. Thank you. I messed up? I was like 15 minutes, and then was it like 30 minutes? Or like I thought I was like 15 minutes, and I was like, we'll come back at 11. And then as I was killing time, I was like, wow, this has been long
Like
15 minutes.
20 minutes,
Oh,
but
all right.
nice
Then maybe
break.
I wasn't wrong then. Okay, good. All right. Okay, great. Madam Secretary, you call us back and then call us back in when you get a chance.
The board is back from a short break and is returning to its hearing session. Would you like me to call the next case?
Yes, please. Thank you.
The next case is application number 16930A of National Association of Realtors. It's a self-certified request pursuant to Subtitle Y, Section 704 for a modification with hearing of the order and application number 16930 to remove condition number 3, modify the approved plans to allow removal of internal and exterior loading areas, as well as removal of an internal service and delivery area, and pursuant to Subtitle X, Section 901.2 for an application for a special exception under Subtitle C, Section 909.2 from the loading requirements of Subtitle C, Section 901.1 and the loading size and layout requirements of Subtitle C, Section 905.4. And this is again to allow the elimination of existing loading space and loading berth on an existing office building. It's located in the D3 zone at 500 New Jersey Avenue Northwest, square 627, lot 13. As a preliminary matter, there are 3 proffered expert witnesses, Juan Maharaz and Naveed Tarani as experts in architecture who are not in the witness book, and David Solomon as an expert in transportation who is in the witness book.
Okay, thank you. If the applicant could hear me, if they could please introduce themselves for the record.
Certainly, David Abitable of Coulson and Stores, Land Use Council here on behalf of the applicant. We also have Bradley Clark from Cushman and Wakefield, who is here as the representative for the owner, and then we have members of the architectural and transportation engineering team.
Okay, who was it that you needed to be admitted as an expert, Mr. Abitable?
So it would be Daniel Solomon from Grove Slade as an expert in transportation. I believe you all have seen Daniel before. And then the other person, we have 2 architects with us today. We actually would only ask that Naveed Tarani, who is on from ZDS, be proffered as an expert in the field of architecture based on his resume and experience.
Okay, Mr. Solomon, we've seen before. And so I'm just, can you tell me where Mr. Chahani's resume is in the record? You happen to know offhand, Mr. Abitable?
Yeah. And can I add that this is Naveed Tarani. I've been added as an expert as part of a PUD or 2 that I've done before. So I thought I would be already in the system, but
his resume is included as a part of Exhibit 16E of the record. His resume is on page 2 of Exhibit 16E of the record.
Got it. Thanks. All right. Well, either way, Mr. Tahani, I don't know. I think the book goes over from the zoning commission, but if not, I don't have any issues with you being admitted as an expert in architecture, being that you are an architect and that I see from your resume here. And unless my board has any issues with that, please raise your hand or say something. Hearing none, we're going to allow you into our book, whatever that is.
appreciate it.
And then let's see, Mr. Abitable, why don't you go ahead and walk us through your client's application, why you believe you're meeting the criteria for us to grant this particular relief. I can't remember, when did this original proposal get granted? Do you know?
2002 was the original approval.
Okay.
So it's an older case. The building was constructed and completed about 20 years ago.
Yeah, no, we all know where well, I think most of us know what the building is.
Yeah.
It's a very unique building. And so,
right.
Okay, great. All right, why don't you guys walk us through your presentation?
Great. All right, we'll do that. And Mr. Young, if you could bring up our presentation, that would be fantastic. And I will present a summary. So good morning, Chairman Hill, members of the board, David Abitable with Coulson and Stores, Land Use Council, the applicant, joined by my colleague Derek Wallace, and also joined, as I said, by Bradley Clark of Cushman and Wakefield, representing the building owner, Naveed Tarani and Juan Manaras of ZDS Architects, and Daniel Solomon of Grove Slade. And we're here today to present an application that will permit upgrades and renovations to the existing commercial office building at 500 New Jersey Avenue Northwest. And Mr. Young, if we could advance the slide 4, please. Thank you. So the existing building, you can see here, it's, as you noted, Chair Hill, very distinctive, was constructed about 20 years ago pursuant to a BZA order that approves special exception and variance relief from a number of provisions of the zoning regulations. The relief was necessary because the property is actually quite small relative to the overall area around the building, especially given its downtown location. And among other areas of relief, the board approved relief from the requirement to provide an internal loading berth. So instead, the approved building was constructed with an internal service delivery space, which you can see here on the lower image. It's number 4. And then also an outdoor loading space that was sort of just outside the building in public space, which is where that dumpster and that parked car are in this image here. And so what NAR was planning are selective renovations of the ground floor of the existing building to improve its operations and marketability to tenants. So now if we could skip ahead to slide 9, please, Mr. Young. I apologize for sending you backwards and forwards today, but I thought this was the quickest way to get through this. I'll start speaking. It should be the plan of the existing building, slide 9. There we go. Thank you very much. So the existing lobby, which is number 3 here, is incredibly narrow, and it's located right up against the existing service delivery space, which is number 4 on this image, which is where the trash and service area is located. So the existing floor plan does not work, to put it succinctly. So we can skip ahead 2 slides, please, Mr. Young. One more, please. Thank you. So you'll see here, here's the proposed floor plan. And what we're proposing to do is, in part, bumping out the existing lobby just a couple of feet, but it really will create more room in that lobby. If you've ever been inside this lobby, you walk in and it really is quite narrow compared to what you would expect in a typical downtown office building. So that couple of feet will really create a better experience for tenants and visitors. But the more significant change relevant to the application today is in the back of house space behind the lobby. And what we're proposing to do is really relocate the back of house space, reorganize it so that the office parts of the back of house space will now be sort of behind the lobby where number 5 is, where the mail room and such are. And then we'll relocate the trash area over to where the number 4 is, away from the lobby and away from the regular users of the building. And then if we can go to slide 7, so back 4 slides, please, Mr. Young. What these interior changes will do is permit the implementation of some pretty significant exterior changes. Right now, as you can see in the upper image here, the public space surrounding the building is largely impervious, and this is in no small part due to that curb cut and loading area that's outside the building over on the First Street side, which is the north side of the image here. And as we explain in our application, neither that interior service delivery space or the exterior loading area is regularly used. Instead, it's the curbside loading zone where all of that loading activity happens. And so what we're proposing to do is lean into those established operations and formally eliminate the loading spaces. And this will allow for an increase in the green space and removal of the curb cut on First Street. And you can see that on the lower image, which is the proposed conditions, significant increase in the amount of green space along the First Street perimeter of the building. This is coupled with other changes we're making on the New Jersey Avenue side to also increase green space and public space. And so To achieve this outcome, and if we can go forward one slide, please. And this is the landscape plan that again shows where we'll end up as a result of this relief. Shows again that increased landscaping along the First Street side of the building. We're asking for 2 areas of relief, board members. First is modifying the prior BZA approval to remove that outdoor loading area and the associated condition number 3, which was related to that outdoor approval space. And then the second thing we're asking for is special exception relief from the loading requirements to eliminate that the remaining interior loading facilities. We believe we've met the burden of approval for these areas of relief. With respect to the modification piece, what we're asking the board to do is eliminate the outdoor loading area that was proposed at the time 20 years ago to potentially mitigate the impact of not having an interior loading berth. That was the BZA's original relief. As time has now demonstrated, the outdoor loading area really isn't needed, as the curbside loading area is sufficient to accommodate the building's loading needs. Therefore, eliminating this mitigation measure will not have a substantial change on the impact of the original relief on surrounding properties. We also do not believe this change impairs the integrity of the zoning regulations, since the regulations have now been amended to allow one to get relief from the loading requirements as a special exception. Put another way, originally 20 some odd years ago, eliminating that loading berth was a variance request. Now it's a special exception. So had that loading berth been eliminated today, it would have been totally consistent with the regulations as long as you met the conditions. So modifying the original BZA order to eliminate that loading relief is similarly consistent with the regulations. And then with respect to the special exceptions, we've also met the requirements of Subtitle C, Section 909. As we've explained, the use of the building generates a lower loading demand than the regulations require, and what demand there is can be accommodated by the curbside loading. The property is located in a commercial area of downtown, so curbside loading will not have a negative impact on surrounding properties. And finally, the shift to formalized curbside loading will allow for the elimination of curb cut and otherwise improve the streetscape surrounding the building. Again, as you see on this image, we're here with support from the Office of Planning, the Department of Transportation, and ANC 6E. I'll note that we've worked closely with DDOT and OP over a number of months, really years, to come up with the design for the public space surrounding this property. And that's what led to the consideration of, could we eliminate those loading facilities and make this work from a curbside perspective? And we think that this really does work well for all parties involved. It allows NAR to upgrade to meet their current operational and tenant needs down at the ground level, but it also results in an improved public realm and streetscape surrounding the site. So, on balance, we think we've met all the relevant standards of the zoning regulations, and we are happy to answer any questions the board has. Thank you.
Thank you, Mr. Avenable. Before I turn to the board, could I hear from the Office of Planning, please?
Hi, this is Joshua Mitchell with Office of Planning. We are in support of the application, and we can stand on the OP's report. Thank you.
Okay. I got just a couple quick questions. So the Office of Planning, there were some old there were 3 total conditions, right? We're discussing the removal of condition number 3. Do you, and maybe the applicant also knows this, I mean, the first condition was build according to plans, and so I don't think that's relevant anymore. I don't think we need that condition. And the other was like, the tower shall only be used, the tower proposed on the north side of the building shall only be used as an architectural embellishment and not used for any other purpose. Does the Office of Planning know what the board was talking about at that point in time?
At this time, I am not aware of the exact nature of that condition. I would also just defer if the applicant also knows as well, but that didn't come up in our analysis in terms of what they're proposing.
So the Office of Planning doesn't necessarily think that condition is necessary at this point?
No, sir.
Okay. Mr. Avenable, do you know what that was about?
We did not handle the original case, but I suspect, based on the way that condition is framed, that there was perhaps some concern that the tower element, the architectural embellishment, could be used as functional space, and there has historically been a ruling, sort of that when you have an architectural embellishment that goes above the height limit, it is only supposed to be architectural. It is only supposed to be design purposes only. It is not supposed to have any sort of functional space or use within it, because otherwise that could create a violation of the Height Act, and or the zoning regulations. So my guess is it was just attempting to clarify that. The actual tower element as designed is totally unenclosed. It's just a structural spire, that doesn't have a roof on it. It doesn't have walls on it. So I think the intent of that has been met and made with the design of the building.
That's fine. I
That's
thought
my guess.
got it. I thought maybe if they were using it for a a cell tower or something like that. I don't know. But anyway, so my board members, I'm kind of oddly enough, I'm interested in leaving that as a condition just because it was there before, and I don't think the applicant has any issues with that condition. But other than those questions that I had, do my board members have any questions, Mr. Blake?
Sure. I'd like to ask the applicant to elaborate a little bit on the conversations with the Department of Transit. I'd like to understand a little bit why they would recommend the inclusion of a TDM plan in their proposal, where our focus with the LMP makes sense. Curious to know about the why the TDM is even factored in here.
Good questions. I'll start and then turn it over to Daniel to speak a little bit more about the TDM piece of it. Uh, there were extensive discussions with DDOT. They started starting just at the public realm design, at that level, with sort of the public space size of DDOT, not the planning side of DDOT, for a couple of years. And over time, they pushed us to increase the amount of green space around the site. And that ultimately led to sort of the question, hey, could you get rid of the curb cut and get rid of the loading space altogether? And we determined, hey, that actually works well for us. So that was part one of the DDOT conversations. We then brought the folks from the planning and sustainability side. And actually, we ultimately, DDOT as a whole, we've had a preliminary design review meeting with a lot of the disciplines there. They've reviewed this plan. They've generally blessed it. And those conversations then shifted to some of the other transportation impacts and looking at, okay, if you eliminate that loading berth, can you accommodate your loading needs? We worked with them to scope the transportation study. They agreed to that. Daniel can speak to the details. And yes, they of course said, well, we need a loading management plan, and we agreed to one. In terms of the TDM piece of it, I think it is standard practice for our colleagues at DDOT to look for, get applicants to commit to TDM measures whenever they can. We don't disagree that perhaps this is unnecessary to mitigate the specific impacts of the relief we're requesting here, but we nevertheless put one together to get ourselves through the DDOT process. And Daniel, I don't know if you have anything else to say on that.
Nothing else to add there.
I guess maybe put another way to take the bait of the question. If the board were to choose to not require the TDM plan, we wouldn't necessarily fight you on that, but we also understand if you want to include it as a condition because DDOT did. We're prepared to live by it if need be.
Thank you, Mr. Chair.
Commissioner Wright?
Thank you. I support definitely including the TDM plan that has already been offered. And I do have a question that maybe the transportation consultant can answer, which is functionally, how will trash removal happen? And how will moving in for new tenants into the building happen? I guess I do understand the idea of on-site loading area and then you're eliminating that. And I guess I just would like to get a little more information about with the street loading. Does that mean every time trash is picked up, dumpsters will be wheeled across the sidewalk to a trash truck, or whenever someone moves in, the moving truck will be on the street and all of the items will be wheeled across the sidewalk into the building?
So what we are doing with this proposal is essentially standardizing and formalizing what exists out there today. So the way the service and delivery space was oriented and the way that the building was functioning is that trucks would pull up adjacent to the curb cut and then roll trash and goods from curbside to the building itself. So what we are doing here in essence is improving streetscape while formalizing existing operations and then also agreeing to a loading management plan. So that is even further formalized with DDOT. We've had preliminary conversations with DDOT about how the design of the curb might be rolled so that goods can be wheeled from the street up onto the sidewalk and then to the building. That'll get formalized as part of the public space approval process, but DDOT is on board with the design that we have here, and it'll be further fleshed out as we go through the public space process. So we're pretty confident with the solution that we've come up with.
Great, thanks for that additional information.
Absolutely.
Okay, anyone else for questions? Okay, Mr. Young, is there anyone here wishing to speak?
We do not.
Okay, great. I suppose, and we can have a discussion about this once we're done with the deliberations here, but I guess Commissioner Wright, there was kind of a little bit of a discussion also with OZLD as to whether or not the TDM plan was kind of revisiting the original application as opposed to this particular modification. And so whether or not that does or doesn't get put in as a condition, Mr. Avidable, would you guys be doing the TDM plan anyway?
Yes, I mean, for one, we're still going to have to go through the public space approval process in the public space committee. And so DDOT will have that process to ask us to make those same commitments anyway. So the long, the short of it is we'll do it regardless because we've already said we would.
Okay. All right. Let's see. Anyone else have any questions? Okay. I'm going to go ahead and close the hearing and the record. And Mr. Young, if you could please excuse everyone. Okay, thanks. Yeah, I mean, like we've all seen this building. Like the building is just I love the building. I mean, I've never been inside the lobby, but I want to go inside the lobby now before, if this passes, it changes to see how small it was. As far as the application goes and what the applicant has put forward, I'm comfortable removing the condition and then granting the further relief as put forward. I also mentioned before that for whatever reason, I'll just keep the second condition with the tower, just because I don't think they're going to do anything with it. It's been there forever that way now, but considering that the board is whatever BZA group was here 20 years ago, they put it in there, so I don't really have an issue with that being a condition. And I mentioned about the PDM plan versus the loading management plan, my thoughts on that. However, I'm also happy to go with whatever way the board wants to go on that. But I do think that the loading management plan is something that we should include as a condition. So let's see. With that, I'll go ahead and go to you, Mr. Smith.
I agree with your approach to this particular case. I am in support of the removing. In support of the special exceptions, and just like Ms. Wright stated, I am in support of including the TDM plan as well as the loading management plan in light of them removing the loading zone and to properly manage any type of loading requirements that would happen in the right of way, given that this is along New Jersey Avenue, some fairly major streets here. I would also support keeping the condition that you referenced about the tower as well, given that I don't think that's causing too much heartburn. So I'm comfortable with the approach that you have suggested.
Okay, I'm fine with going with that as well. Mr. Blake?
Yeah, Mr. Chairman, I'm in favor of removal of condition number 3. Believe the applicant has met the burden of proof to be granted the requested special exception relief. I would prefer that the TDM plan be referenced, and I would definitely support the inclusion of the load management plan, because it is a critical part of the removal of the alterations in the loading area. So for that reason, I again would be in support of the special exception, support removal of condition number 3. But I do have some issues with the inclusion of the TDM actually in the order. I'd rather do it by reference. There you go.
Okay, so back on that item, I'm fine to, I also had mentioned before that I thought that maybe the TDM plan was not something that we should put in as a condition, but if my fellow board members thought it needed to be a condition, that's fine. Also, now what is on the table is just referencing it in the order, which is also something we can do. And the applicant has put forward that the TDM plan would be something that they would be using, or sorry, implementing regardless of what the board does with this, because they still have to go through the public space process. Mr. Smith, are you comfortable referencing the TDM plan?
I'm comfortable with that.
Commissioner Wright?
Yes, I'm comfortable with referencing it in the order. I don't want to just leave it entirely to the public space process, but I also am comfortable with it not being a formal condition.
Okay, thank you. I don't know where I was. Did everybody deliberate? Okay, everybody deliberated. Sorry. So, okay, I'm getting a little lost. All right. Okay, I'm going to go ahead and make a motion then to approve application number 16930A as captioned and read by the secretary, including the condition that they include the TDM plan as provided. We will reference, including the LMP condition, the loading management plan. We will reference the TDM plan in the order. And also we will still include condition number 2 from the original order, which was the tower proposed on the north side of the building shall only be used as an architectural establishment and shall not be used for any other purpose. And ask for a second, Mr. Blake.
Second.
The motion is made and seconded, Madam Secretary. If you take a roll call, please.
Please respond to the chair's motion to approve the application with conditions. Chairman Hill?
Yes.
Vice Chair Blake?
Yes.
Mr. Smith?
Yes.
Commissioner Wright?
Yes.
Staff would record the vote as 4-0 to 1 to approve application number 16930A with conditions on the motion made by Chairman Hill and seconded by Vice Chair Blake.
Great, thank you. Madam Secretary, you may call our next order of business when you have an opportunity.
Next is application number 21261 of John Means and Evelyn Ballard. This is a self-certified application pursuant to Subtitle X, Section 901.2 for a special exception under Subtitle F, Section 5201 from the open court width requirements of Subtitle F, Section 209.1. This is for a new 3rd story with roof deck and an existing 2-story attached principal dwelling. It's located in the RA2/DC zone at 1825 S Street Northwest, square 132, lot 13.
Okay.
Good morning, everyone. Can you hear us okay?
Yes. Could you please introduce yourself for the record?
Perfect. And as I do, Mr. Young, our architect, Pete Nettlebeck, is also a participant. If you're able to admit him, I believe he was sworn in case there are questions. While you're doing that, I'm John Means. I'm the resident at 1825 S Street Northwest, along with.
Hi, I'm Evelyn Ballard. John and I are married, and we live here with our two wonderful and wild children, Nathan and Lily, who we walked to our neighborhood public school this morning. I moved to DC in 2007, fell in love with DC, fell in love with this neighborhood, and I've lived in the neighborhood since then. And then we recently moved to 1825S.
Okay, great. Thank you. Mr. Nettlebeck, can you hear me? And if so, could you introduce yourself for the record?
Hi there. Sorry, my video's not working for some reason. My name is Pete Nettlebeck. I'm an architect. I've worked with John and Becky on this project. And can you hear me all right?
Yeah. Mr. Nettlebeck, are you going to present or is your clients presenting?
John and Becky will be presenting today.
Okay, great. All right. Let's see. So, Mr. Means and Miss Ballard, I believe,
Yes,
if
sir.
you all want to go ahead and walk us through your application, and we will see where we get in terms of any questions that we may have. I'm going to put 15 minutes on the clock so I know where we are, and you can begin whenever you like.
Thank you.
Great. Thank you, Mr. Hill, and thank you to the whole board for having us today. Mr. Young, if you're able to pull up exhibit number 32, which is our presentation.
And that's our daughter, Lily, there.
This is our daughter, Lily, on the front steps of 1825 S Street. I'll get into the case. We just finished the primary renovation of the residence. This was a burned down row house at 18th and S. We previously lived at 17th and S for about 12 years and saw the opportunity to help restore this home. So we've completed the main renovation and are in the process of permitting the third floor addition, which I can share more about in a moment. If you go on to the next page, this is, I'll give it a second to reload. Mr. Young, if you're able to click ahead. You can see the particular site between 18th and 19th Street on S in Northwest. The home was originally built in 1895 as part of the DuPont Circle Historic District. It's not itself registered, but Historic Preservation and the HPRB have been involved in this process and have previously signed off and approved the third floor addition that we're discussing today. If you'll go to the next slide, Mr. Young. You can see on this slide, apologies for the small text, the matter at hand for this committee or this board, sorry, is the open court in the rear yard where we are, the building is currently non-compliant as it was built in 1895, and we're asking for an exception to continue to extend that non-conformance as we add this third floor addition. I believe the dimensions are on the next slide. Yes, they are. So you can see this as an infill property in 1895. This was a 15-foot lot, which meant that only a 4-foot wide court was available at the time. So this is a existing 1895 property with that 4-foot court. And again, we're proposing to add a third floor on the existing structure. We are not changing the footprint or the coverage ratios for the property. So it's just to extend that 4-foot court. By current zoning, it would be slightly over 7 feet wide if we were to build that court today in the house, which would take up half of the lot width. If you go into the next slide, Mr. Young, we've put a map here showing support letters that have been received from the immediately affected neighbors, both the ones that directly see the court and the 5 in the condo building next to the court. This has been reviewed through the land use committees of our ANC now multiple times, given the historic components and the zoning criteria. And the main ANC, it has been approved unanimously in committee twice and in the ANC now twice as well. So it's widely supported both from our neighbors and through the ANC. And I believe Office of Planning and DOB have also submitted their support for the request. And then just to let me give you a visual representation of what we're asking for, and then I can pause there. We can go through more plans if helpful. Yeah, can you go to slide 8, Mr. Young? This is the rear of the home, and we just wanted to give a visual of the court. You can see that at this point, condo developments on each side of the project of our home have extended up to the third and the fourth floor above our unit, and our court in the section just adjacent to the condo development on the left-hand side, that's to the east of our property. So again, our proposal is to add a third floor, and if you want to see what that would look like, if you jump to page 10, Mr. Young, we'll just skip 2 slides, so we're just focusing on the rear. We would continue to extend up this new window line that has been created, again, previously approved by HPRB, the Historic Board, and DOB, to add this third floor and the roof deck. So again, the matter at hand for the BZA is to continue to allow this court to be extended upwards. And I will pause there to see if you have questions. I'm happy to go through other parts of the plans, but we wanted to keep it relatively quick for you.
Thank you, Mr. Ballard. Let me do this. Before I get to my board again, I'm going to go ahead and turn to the Office of Planning.
Good morning, Chairman Hill and members of the board. This is Mike Yurkovich, Development Review Specialist with the Office of Planning. OP recommends approval of the requested special exception relief to open court with. OP stands on the record of our report. I'm here to answer any questions. Thank you.
Okay, great. Thank you, Mr. Yurkovich. Does the board have any questions of either the applicant or the Office of Planning? No. Mr. Young, is there anyone here wishing to speak?
We do not.
Okay. Let's see. Mr. Ballard, do you have anything you'd like to add at the end?
No, thank you for the time and consideration.
Okay, thank you. And Mr. Young, go ahead and close the hearing on the record. Okay, I thought this was actually a relatively straightforward request. I didn't have any issues with the application nor the way that they're meeting the criteria for us to grant this particular relief. I appreciate the effort that the applicant has gone through in terms of both their presentation as well as all of the community outreach that they've done. I actually appreciated the sightline presentation the most in terms of the application. I found it helpful. And then also it is nice to see that they were able to get support from some of their neighbors in the area, as well as that of the ANC. And I do appreciate the analysis that the Office of Planning has put forward in their report, and I'll be voting in favor of this application. Mr. Smith, do you have anything you'd like to add?
Nothing to add. I believe also that this is a very straightforward application. Given the size and scale of the adjacent buildings, I think that this will this particular addition would not have any undue impact on any of the adjacent neighbors. So with that, I will support as well.
Thank you. Vice Chair Blake?
Yes, Mr. Chair. I would also like be in favor of the application. And I would also echo the fact that I do appreciate the line of sight perspective provided by the applicant. I thought that was very helpful and will be in support of the application. Thank you.
Thank you. Commissioner Wright?
I support the application. I just want to note for the applicant's benefit, I lived in this neighborhood, immediately in this neighborhood, like immediately from 1987 until 2000. Had my first child while living in this neighborhood, and know it's a great neighborhood to raise kids. So I really appreciated their presentation and their commitment to being in the city and raising their children in the city. And I think it is a straightforward application. They're doing, it looks like a very good job of renovating and appropriately adding on to a historic building. And I'm fully in support of the application.
All right, great. Thank you, Commissioner. Well, Commissioner, being there in the 80s, good for you. All right, let's see. Okay, I'm going to go ahead and make a motion then to approve application number 21261 as captioned read by the secretary, and ask for a second, Mr. Blake.
Second.
The motion been made and seconded, Madam Secretary. We'll take a roll call, please.
Respond to the chair's motion to approve the application. Chairman Hill,
Yes.
Vice Chair Blake,
Yes.
Mr. Smith,
Yes.
Commissioner Wright.
Yes.
Staff would record the vote as 4-0 to 1 to approve the application. Application number 21261 on the motion made by Chairman Hill and seconded by Vice Chair Blake.
Great. Thank you, Madam Secretary. Give me one moment, please. Okay, Madam Secretary, you may call our next case when you have an opportunity.
Next, the board is returning to application number 21262 of Ian Packman and Ellen Carlson. This is a self-certified application pursuant to Subtitle X, Section 901.2 for special exceptions under Subtitle D, Section 5201 from the rear yard requirements of Subtitle D, Section 207.1 and the lot occupancy requirements of Subtitle D, Section 210.1. This is for a two-story rear addition to an existing two-story attached principal dwelling located in the R3/GT zone at 2728 O Street Northwest, square 1239, lot 854. Previously, the board granted party status in opposition to Prue LaRocca and April Lynn Buller and Jamie Peva. And then there's also a preliminary matter. The applicant has filed a motion to waive the filing deadline to allow in submissions responding to OP, which are in the record in exhibits 22 and 20 through 22B.
Okay, can you repeat that last item again, Madam Secretary? Sorry.
Yes, the applicant has submitted a motion to waive the filing deadline to allow in late submissions that are responding to the Office of Planning, and that's in exhibits 22 through 22B. So they're already in the record.
Okay. I'm going to go ahead and allow that into the record unless my board members have any issues, because I want to see exactly what is going on with that item. And if my board members have any issues, raise your hand or say something. Okay, thank you. Go ahead and allow that into the record, please. Can the applicant hear me? And if so, could they introduce themselves for the record?
Yes, thank you, Mr. Chairman and board members. My name is Marty Sullivan with Sullivan & Barrows here on behalf of the applicant.
Okay, thank you. Could Ms. LaRocca please introduce herself for the record?
Good morning, Prue LaRocca. I'm the property owner at 1363 28th Street Northwest.
Okay, great. Thanks, Ms. LaRocca. Ms. LaRocca, is your camera working? If not, that's okay.
I'm not sure.
Okay.
Maybe is it now?
No.
Huh.
Maybe you can play with it. If you just try to play with it for a little. Oh, there you go. Great. Perfect.
Okay, now am I working?
Yes. Thank you. Thank you. All right, and then let's see. Is it Miss Bowler? Okay, great. And well, could you guys introduce yourselves, please? You're on mute. You guys are on mute.
There we go. Sorry. I'm April Bowler. I'm the owner of 1359 28th Street, and this is my fiance, Jamie Peva.
Okay, great. Thank you for joining us. Let's see. Mr. Sullivan, are there other people here with you? I see the commissioner, I think. Let me see where the
Yes,
commissioner.
I think the owners should be here, and then the architect is here, Kylie Wilfong Cullen is
Okay.
the project architect.
Give me 1 second. I saw the commissioner there for a second. Commissioner, could you introduce yourself for the record? You're on mute, Commissioner.
Hi there, Gwendolyn Lowe's ANC2E Commissioner. Thanks for having us today.
Great. Welcome back. Let's see. And then Ms. Cullen, is it Ms. Cullen? Could you introduce yourself?
Yes, my name is Kylie Wilfong Cullen. I have been working with the homeowners on this project for a while, and obviously lead architect.
Great, thank you. Mr. Sullivan, who's the homeowner?
I think they're here. It's
Yep.
Ian Packman and Ellen Carlson.
Great.
And we are here.
Mr. Packman, can you introduce yourself for the record?
Yes, Ian Packman and Ellen Packman, the homeowners at 2728 O Street.
Okay, great. Thank you. All right. So everybody, first of all, welcome. And what we're going to try to do here is work through the application. Just so you all know, the board has taken a look at the record, and we hear cases every Wednesday. And oftentimes there are differences of opinion as to what is going on. And then the board is to take a look at the criteria that we are faced with and determine whether it can be approved or can't be approved, or maybe there should be some things that need to change in order for it to be approved. But what I'd like to point out is we're all going to do our best to kind of get through this as reasonably as possible, right? And also, since everybody's neighbors, everybody has to live with everybody after this is over. So let's try to move along as best we can, is all I'm just trying to say. So that being the case, Mr. Sullivan's going to be able to go first. And Mr. Sullivan, if you want to go ahead and give us your presentation and why you believe your client is meeting the criteria to grant the relief requested. I'm going to put 15 minutes on the clock just so I know where we are. But you can begin whenever you like.
Thank you, Mr. Chair. If Mr. Young could please load the PowerPoint presentation. Next slide, please. So the address is 2728 O Street Northwest. A quick overview: the applicant's proposing to construct a rear addition. This consists of expanding and enclosing an existing first floor sunroom and a second story rear addition on top of that. It's essentially a rear infill addition, so the entire rear wall of the property will align with the adjacent property's rear wall to the east and a little short of the rear wall to the west. And actually, I'll show you, it's a portion of the applicant's property which is already at the 9.3 feet distance. So they're filling in a portion of their property which is already at that point. So as a result, the lot occupancy is going to increase to 68.3% from, I think it's 64.6 currently. And rear yard setback is currently 9.3. It's going to remain 9.3, but for a distance that goes across the entire property now. The Office of Planning is recommending approval, and ANC2E voted not to support. Next slide, please. The general special exception criteria the board's authorized to grant, where in the judgment of the board, the special exception is in harmony with the purpose and intent of the zoning regulations and zoning maps and will not tend to adversely affect the use. Properties located in R3 GT zone, which is intended to permit attached row houses on small lots and limit permitted ground coverage of new and expanded buildings and other construction to encourage a general compatibility with the siting of new or expanding buildings and the existing neighborhood. Property will remain a single-family row dwelling, and the proposed addition is effectively rear infill, aligning the rear wall with existing rear walls on this, as you'll see, a row of 3 houses facing O Street on very small lots. Next slide, please. The specific criteria, which we will go through and you'll see in the photos and the plans, as mentioned, the addition is going to line up with neighboring properties. It's on the south end of this property, so the Miss Bowler's property is directly south of this. The shadow study shows absolutely zero shadow, zero shade, as you can expect, because it's tucked within 2 buildings and the shadow doesn't go to the south. Regarding privacy and use and enjoyment of neighboring properties, for the same reason, there's no impact at all right or left, east or west, because it's packed in against existing walls. Regarding to the south, the 9.3 yard rear yard, which is adjacent to the side property line of Miss Bowler's, will not change. There are currently several windows and an open screen porch facing that property. If anything, this will be an improvement of the privacy situation. The Office of Planning noted that the view doesn't substantially change the privacy situation. I would argue that it significantly improves it because you're trading an open screen porch and windows for walls and windows. And again, this is because it's perpendicular to Ms. Bowler's property. It's her side. So she goes out the side of her property in a row house district and has 9.3 feet between her and the next house. Regarding visual intrusion, the addition is barely visible from O Street, and we do enjoy OGB approval. Next slide, please. There you see an overhead view. So that open notch, the subject property is 27280. There's this open notch here, and that's what's being filled in. It's 2 stories. The neighboring properties are a story above it. And we will not go as far as the existing rear wall on 2730. We'll line up with the applicant's current existing rear wall on the L. And also that lines up with the 2726 neighbor to the right. Next slide, please. There's the existing situation. That is the screen porch, and the building to the right of that screen porch is the applicant's property. So they currently have 4 windows facing to the south in addition to the screen porch. Next slide, please. It's the view from the other angle. There you see the at-risk window you've probably seen and read about in the record. That's to the property at 2730 of Miss LaRocca. That building has 3 walls full of windows. That's a hallway window. And we can get into the discussion of at-risk windows, maybe more so in my rebuttal, but typically the board doesn't consider the relevance of at-risk windows, and there's reasons for that, and I can go into that more detail if the board would like to hear that. Next slide, please. And now I'd like to turn it over to Ms. Wilfong-Cullen to take you through the plans. Thank you. Kylie?
Hello, everyone. Thank you for allowing us to present. As you can see, this is the survey. Our proposed addition, as Marty noted, does not protrude any farther than their existing rear wall. That rear wall has the 2 windows on it, kitchen on the first level, and then a bathroom on the upper level. Next slide, please. Next slide, please. When we were approached by these clients, they had mentioned that previously, before they had purchased the house, there may have been a powder room on level 1, and that was eliminated during a renovation. So their drive and interest in this project started with adding a powder room to the first level because they did have friends with mobility impairments, and it was going to be easier for them to access a powder room from the first level rather than the upper level. Next slides, please. So you can see the roof plan. Next slide, please. And so this is what we were, we started out with. So as you can see, 3-season room there. The only access to the back rear yard from the first level is through that 3-season room. There is also a areaway down into the basement. Next slide, please. Upper level here, primarily a bedroom, and then the right side of the house is an extension of that bedroom and also the bathroom. Next slide, please. So the proposal shows a powder room that is stacked on the right side of what was previously the screened-in porch. The reason for that is that helps align with the plumbing a little bit better, and then allows for access out the left side of the building. And as you can see, it aligns with the existing rear wall of their building. Next slide, please. On the upper level, this house, while it is very beautiful, is a pretty small footprint. So we were looking to add an office above the previous three-season sunroom, as well as a walk-in closet. That walk-in closet obviously does not need a window in it. It was required by OGB that we look at this. We examined this in terms of a sleeping porch, so that's how we landed on the exterior design. And we're able to eliminate the need for a window in the walk-in closet, which is really primarily adjacent to bedroom windows from the south property, from our understanding. Next slide, please. As you can see, the roof plan, we are proposing a skylight in the walk-in closet just to get light in the space. Next slide. And in the section here, you can see sunroom as well as the walk-in closet. Next slide. That's the existing conditions with the party wall with the at-risk window. Next slide. And here is where we landed with OGB. As you can see here with the office windows, and then we were not required to have a window at the walk-in closet. And as Marty noted, it does include this space a bit more on the back side of the house. Next slide. Here are a couple renderings. As noted, it does not, the rear wall does not extend past where we are currently. Next slide. View from the street, which is very minimal. And then we've got our sun studies. So since we are on the south side of the building, we don't have anything, of course, the sun is on the south side. We're not really casting any shadows on anything but our own building at minimum or at most. So in terms of blocking light and air, we feel very strongly that we aren't impacting the adjacent neighbors since we are staying within the existing footprint, and we are on either side of us and behind us have a full story above what our homeowners, our clients have. Next slide. Of course, this is summer solstice for the proposed. Next slide. And then, of course, winter solstice. Existing. Next slide. Proposed. Next slide. I think we also have the equinox. Yeah. So that's existing. Next slide. And proposed. Next slide.
Thanks, Kylie. I think I'll talk about these photos. So these are views from the existing windows in the applicant's building. Next slide, please. This is a view from a window looking south. Next slide, please. Here's the view from the screen porch looking south on, that's Miss Bowler's building, her side wall there. Next slide, please. Same view. Next slide, please. And this is the corner building. This is Miss LaRocca's building. She has windows on 3 sides. And the window, the at-risk window that's going to be covered up is a hallway window. Next slide, please. Next slide, please. And that's the 3rd side of the building. That's from 38th Street. Next slide, please. 28th. Next slide. And that's it. Yes, so that's it for the presentation. Thank you.
Okay, great. Thank you, Mr. Sullivan. All right. You basically went 15 minutes or so, 13 minutes. We'll go with 15. All right. So what I would like to do, so everyone knows, I'm going to go through all of our testimony and then we can ask questions. Again, first the board can ask questions also when they want to, but if I can just kind of get through testimony first, that would be helpful. Ms. LaRocca, can you hear me?
I can. Can you hear me?
Okay, I can.
Good.
If you want to go ahead and give us your testimony,
Okay.
And you can begin whenever you like.
All righty. I'm the owner of 1363 28th Street, which is the same building that the applicant calls 2730, but my lot address or my tax address is 1363. It's a multifamily building at the southeast corner of the intersection of 28th and O Street. The property's been in my family for more than 60 years, and I'm also a 3rd generation Georgetowner. My property is to the west of the applicant's property. I think the applicant portrays their request as a simple and innocuous infill project to align their existing 1-story porch addition with my east wall and also build a second story on top of that. What they haven't adequately described is the related histories of our properties, the significant physical and financial impact of their project to me and my property, or the non-conforming nature of their property. Most importantly, they failed to provide the board with a compelling reason for granting their requested relief, or demonstrated how your approval of the relief adequately protects me, other abutting neighbors, and the policies set forth in the zoning regulations unique to the Georgetown Historic District. So I've done a little research, and according to the Office of Planning's History Quest website, my building was constructed in 1859, the first brick building on the block. The applicant's house was originally constructed as a rear addition to my building in 1887. According to the historic fire atlases dating to the mid-20th century, it wasn't until at least the 1960s that the applicant's house had a shallow rectangular footprint, as is typical for a rear addition. It's unclear when the house was expanded to the two-story L shape it currently possesses. And of course, on top of that, it appears that the one-story porch addition was constructed within the last decade by a prior owner. And though all of the neighbors have searched mightily to try to find a record of permitting or review by the old Georgetown Board of the addition, we haven't been able to lay hands on one. Why am I getting into this? I believe it's important to have the context information, especially when the applicant seeks to describe my second-story window, the one their project would completely cover over and brick and block, as an at-risk window. Windows similar to the windows in new construction. It's not at all similar to at-risk windows in new construction. And certainly everybody that I'm hearing that talks about this considers an at-risk window something that you don't even have to consider. It's hard for me to understand why a property that was built on my lot originally, there was no lot line between my property and the applicant's lot line, why all of a sudden we would sort of move to becoming an at-risk window. The situation where you have two kind of complex and intertwined properties isn't unusual in Georgetown. I would argue that that's why the zoning regulations set forth explicit policies for the R3 GT zone. Both of our properties and the surrounding neighborhood are classified as such. The policies include the protection of the integrity of contributing buildings to the historic district, and they provide limiting of ground coverage of expanding buildings to encourage general compatibility between the siting of new or expanding buildings in the existing neighborhood. Subtitle D 1100.2, surely what is being proposed here, where a historic window is being blocked over, fails that test. As I understand the zoning regulation, the special exception requirements, the applicants have the burden of demonstrating a few things, including the light and air available to neighboring properties shall not be affected. Clearly, in the case of my window, that window is one of two windows in a hallway. As I mentioned, it's a three-story multifamily building. That hallway is the only way that tenants of three apartments can get in and out, get into the building and up to their units. So the loss of that light is quite substantial for them. I don't really understand why I would be forced, why in the face of building new construction, I would be forced to bear the cost and the damage to my property for this to transpire. And certainly I can't think of a more negative impact on the building than to have a window completely blocked off. The fact that it fronts on a shared tax lot line does not mitigate the effect or absolve the applicants of responsibility. Despite what the applicants may suggest to you, that you should not consider at-risk windows, I have not found any case similar to this one where a historic window was approved to be blocked over by the board. I'd be happy to be told of one if there is such a one. In closing, I'd like to remind the board of another aspect of the applicant's property that they have minimized in their presentation. Their property is a non-conforming structure that they're proposing to expand quite dramatically. As you know better than I, the zoning regulations strictly regulate expansions of non-conforming structures for reasons just like this, unreasonable impacts on neighboring properties. I hope the board would consider this when deliberating over the applicant's requests. They're not starting from a lot that meets the current requirements of our zone. They're having where now a 2,000 square foot lot or larger is required. This lot is, I think, approximately 750 square feet. So I understand the property is non-conforming. Rather than having a compliant rear yard of 20 or more feet, theirs measures less than half of that and is occupied by an arguably unpermitted porch. Now the applicants are requesting to further expand the building and footprint even further and to add a second story. Respectfully, it's just too much for certainly me, and I think you shall hear from the rest of the neighbors. Thank you very much. All I have to say for now.
Thank you, Ms. LaRocca. Thank you, Ms. LaRocca.
Thank you.
Okay, Ms. Bowler, would you guys like to go next?
Sure. I'm April Bowler. I live at 1359 28th Street, and I have been in this house for, this will be the 14th year. Since my fiance, Jamie Piva, is he's a better public speaker and a less emotional speaker, I'm going to let him speak for us, if that's all right.
Sure, of course.
Thank you. Thank you for having us, Mr. Chairman and members of the board.
Mr. Piva?
Well, good morning, Mr. Chairman and members of the board. We oppose granting a special exemption for 2827 O Street on lot occupancy requirements and setback requirements. It seems that the proposal, it seems to be the justification for this proposal is that since the lot is already at 63%, then why not 68%? What's the difference of a little bit more? And this is precisely the definition of exacerbating an already non-conforming condition. And it doesn't capture the scale and the immediacy of this distinct character in the neighborhood in Georgetown. It's a small lot and the houses are close together already. But zeroing in on our specific complaints and why we have party status is our house at 1359 28th Street is directly south of the proposed addition. I'd just like to touch on this part of the statute. The regulation reads, an application for special exemption relief under this section shall demonstrate that the proposed addition shall not have a substantially adverse effect on the use or enjoyment of any abutting or adjacent dwelling property. Then there's an A and a B. A, the light and air available to neighboring properties shall not be unduly affected. So as April says, if you take an empty space and you put something in it, it's affected. And we understand that the word is unduly, but given the scale and the closeness of the house, it's already unduly. So exceeding the space at all creates a problem. But really our big issue is the privacy, is B. The privacy of use and enjoyment of neighboring properties shall not be unduly compromised. This is the crux for us, really. There's been a lot made of the incrementalism in this addition, that since the property is already 9 feet away, then what's the big deal if the rest of the house is held to the same standard? But this is misleading. The part of the house that is 9 feet away is a screen porch and not a real living area. On the existing plans, it's listed as a 3-season sunroom. This is also misleading. There's no heat, air conditioning supplied to this room, and the windows are screens. The pretense that it is a 3-season room is silly in Washington, D.C. It's rarely used. Now, this is important because essentially all of the living that's taking place in the neighbor's house is taking place 15 feet away behind a brick wall. It's not as if it's already at 9 feet away. If you look at the architect's BZA submission dated 12/3/24, which we just did, image number 11 shows that there are 4 windows, 3 on the main part of the house facing 1359 are primarily facing a wall, and the 4th window is in a stairwell. It's clear that when 2728 was built, that there was a clear intention to provide privacy for the neighbor to the south by placing these windows where they are. Each of the peripheral windows on the edges of the houses face blank walls of 1359. The only exception is the middle window, which looks into our 2nd floor window. But that window in 2728 O Street is in a stairwell. So the point is that the occupants of 2728 live their lives 15 feet away on the other side of this brick wall, unless they're in the stairwell or at the edges of the house. And even then, they're apt to see a brick wall on this side. If you look at the addition, the architect's image number 12, it proposes to bring all of that living area within 9 feet, plus a substantial increase in the number of windows, 5 times the current window area. Even the exterior glass door has a glass transom and glass sidelines. There's been every effort to open every south-facing part of the house. The change would be utterly dramatic in every way, both quantitatively and qualitatively. And there's been no mention of this glaring fact in any of the proposals, other than to say it was the OGB that asked for so many windows, not the homeowner, which really doesn't lessen the impact on us at all. I'd like to leave it there. For this alone, I would hope, would convince the board that the privacy of the southern neighbor would be unduly compromised. I could get into the economic impact of this, but I won't because we plan on living here for a long time. But I can't leave it there, for there are other points that need to be made or refuted if you are considering granting relief through special exemption. It is our understanding that subtitle X or 10, 901.6 says that the BZA is required to give great weight to the ANC and to the Office of Planning. As you know, the ANC has passed a unanimous resolution opposing this addition. Not only our own representative, but every other ANC commissioner has agreed that the conditions for a special exemption are not merited. Additionally, this resolution is accompanied by at least 5 additional letters of opposition direct from the neighbors, each of whom has a different and a valid point. We know that the OP submitted a memorandum supporting this addition. However, I've read it, and it should not carry as much weight as the ANC, because to start with, there's at least one untruth. It says that the addition would not be visible from the street. This is clearly untrue, as one can see from the photo taken from 28th Street. Even the original proposal from the subject property shows this. If such a fact can be wrong in the report, does it not call into question all the subjective assertions that it makes regarding whether the surrounding properties will be unduly affected? I know that no one from the OP ever came into 1359 28th Street and looked out our windows. And its assertion that the character, scale, and pattern of the houses would not be affected makes me doubt that they walked down the alley and looked west. But I was present when the ANC commissioner came into our house, assessed the situation, and it was clear to her what a dramatic change this addition would make to the privacy of our house. My point is that if the BZA is statutorily obligated to consider the ANC and the OP's recommendation, the ANC should be given greater weight. Again, I'd like to leave it here, but there's yet another misleading document in the record. There is a letter from Martin P. Sullivan, attorney for the owners of the subject property, addressing the privacy concern. I think to the extent that these arguments are in the BZA members' minds, they need to be refuted. It is telling when a talented lawyer like Mr. Sullivan is tasked with finding reasons why there is not a privacy issue, and these are the reasons that he came up with. Not one of them serves. I'm not going to bring you through them all, but I've already refuted each one of them, except for number 3, where he asserts, for a row house, a 9-foot setback is generous. This too is misleading. Most side yard setbacks are against another neighbor's side yard, where there are minimal windows and no privacy issues. In this situation, 1359 28th Street's side yard abuts 27 28th Street, O Street's backyard with full view of the back of the house. In conclusion, I've been a real estate agent in Georgetown for over 30 years, and buyers are constantly asking me about what might happen next door. Will the neighbors block their sun or change their view or alter the quiet feel of a block? And part of the reason that justifies why people pay so much to be in this neighborhood. And I always tell them that there's 60% lot coverage, and if the neighbor's already over it, that you're protected. If this exception is granted for nothing but the most contrived reasons, what would I tell them? That there's a 70% rule? Who is protected? No one.
Thank you so much for your time and consideration.
Thank you. Thank you both. Okay, I'm going to go now to the Office of Planning, please.
Good afternoon, Commissioners. This is Ron Barron for the record for the Office of Planning. The Office of Planning recommends approval of the requested special exceptions. We are happy to rest on a report that's been submitted in the record. I'm available to answer any questions you may have.
Okay, great. Thank you. Commissioner, are you here?
I am, yes.
Okay, great.
Yep.
Thank you, Commissioner. Commissioner, would you like to give your testimony from the ANC?
Sure. And we appreciate everyone being here today. And I think we know there's 2 special exceptions being asked, rear yard requirement and exception for the lot occupancy requirements. And they're requesting such to widen their home, which if they do widen their home, it will block another resident's window and with privacy implications for the other neighbors. All the neighbors that we spoke to are opposed. And I think the neighbors have become very educated across the communities about special exceptions because they're being sought so frequently, both with rear yard and lot occupancy. And we have a lot of flooding in people's basements. So people have become more educated and more interested in these topics recently. So just to put some context around this, overall, the ANC2E, really our position was neighbors are clear that special exceptions should be granted very infrequently. Thus, for example, why call it a special exception in which a lot occupancy is 60% so light and air can flow? Neighbors strongly support the lot occupancy and rear yard requirements, which are created to prohibit relatively large houses on relatively small lots and to maintain character versus a slow chipping away of uniqueness. ANC2 concurs with the opposition. ANC2E hopes the applicant will resubmit the application to reduce its footprint to what exists today, which is already over lot occupancy and buildup. So thank you, and I hope a compromise can be found.
Thank you, Commissioner. Okay, let me see. Mr. Young, is there anyone here wishing to speak?
We do not.
Okay. All right, so now what we're going to do, I suppose I guess I'll start with my board. Do you all have questions? And also, by the way, we can go through everybody else's questions and the board can also ask questions, which is what I kind of think might happen both ways. But go ahead, Mr. Blake.
Thank you, Mr. Chair. I have a couple questions for the applicant. On the first level, you currently have a 3-season room. That will shift obviously over. That won't be that actively used. Those windows though, will that create a full season room, or will it just be is it a year-round fully conditioned space, or will it continue to be somewhat of a seasonal space? That's my first question.
It'll be a full space, and I can have the architect talk about what's behind that space, because one of those windows is a powder room, so there's not going to be any view out of that. I don't know what the other space is for. Kylie, if you want to
Sure.
answer that, please.
Yeah, the intention is for that to be a conditioned space. And please, I missed the first part. Are we talking about the upper level where the office
No,
is added?
I'm asking about the first level first. I just
Okay.
want to look at let me tell you where I'm going with this. Right now, you have a seldomly used space, let's call it that. And now the question is that going to convert into a heavily used space, or is it going to remain a seldomly used space? Obviously, I see the restroom next to it, which could be seldomly used or frequently used, but it's not going to be a lived-in, aggressively handled space. So I'm just curious about the other space. I do want to talk
Understood.
about the second floor, because the second floor does have some elements. I think that there were windows up there, but it brings forward the upper level with the closet, which certainly does not create a privacy issue because there's no window there. The additional 2 windows that come above that for the office space do create potentially a privacy issue. But that there's some mitigating issues we can address that with. So I'm kind of just getting a feel for the activity level that takes place on the first floor. And then I want to talk a little bit about the second floor and the activity level that takes place there in the incremental
Sure.
space.
Understood. So the existing screened-in porch is obviously in our climate here used occasionally per humidity levels and also temperature levels outside. The intention for the sunroom is for it to be a conditioned space that will be more comfortable for the clients, but the anticipation is that wouldn't be used more often than it's not going to be a lived-in space. You know, it's a sunroom that they'll spend time in occasionally. It's not a very large space, so it's not like when they have friends or family over. It's not a space that can really have multiple people in it. There's space for maybe 2. The driving factor for the windows on the south facade was actually OGB. Our initial submission to OGB showed only 1 window. Essentially, if you take that window in the stair that's been discussed and pull that straight out, and that's the window that we were going to keep for the upper level because of privacy concerns. So OGB, working with them, we went back and forth a number of times and had discussed they wanted more windows to make it look more aligned with a sleeping porch. Marty, do you have any other comments on that? Because I know that the windows have been something that we've discussed internally quite a bit.
No, I don't have anything else. I mean, the applicant would be fine if those windows had to be frosted or something as a condition of mitigation, because there's no view that they're concerned about. I mean, sometimes I don't like to offer that, because the applicant also should have the right to look out and see if they have a child out in the yard. And so, but if that's what we need to do to get approved, that they're certainly okay with that. We've talked about that beforehand. I didn't think it was necessary in this case because we have windows. They're just getting a few feet closer. I'm not sure we're focused on how small this addition really is. As Ms. Collin mentioned, it's not a large space at all. But yes, if the board would like to see that, we could certainly agree to that.
Yeah, Mr. Sullivan, I agree. I think that the frosted windows on the office space would certainly accomplish a lot in terms of privacy for the south property. On the lower level with the laboratory, certainly even if you did a frosting on the lower portion of that window, it would also have the same effect. I suspect if you're sitting there, I see the toilets next to the window, it wouldn't, have that negative effect on privacy, even if you would sit there for a while. So I think that it's, I think that may address some of those issues. So thank you. That's very helpful. Thank you very much.
Go ahead, Commissioner Wright.
Just a question that maybe the applicant or Ms. LaRocca can respond to. This building was once a portion of Ms. LaRocca's property. It was an extension. And at some point, it was subdivided off and became its own lot with its own building, well, same building, but it became a separate residence on its own lot. Does anyone know what year that subdividing happened? You're muted, Ms. LaRocque.
No, I've not been able to find the date specifically. It's sometime after 1945 and before 1960. And when it was initially a rear addition, it was a one-story addition. And it wasn't in the current L shape. It was just, if you will, more like an I that goes between my building and 2726.
But you were not associated with ownership of the building. Your family was not associated
So
with
my
ownership.
my grandmother bought the building in the early 1960s, and it was a separated lot at that time.
Got it. Thank you for that information.
Yeah, and the window was there at that time.
Okay, thank you.
I have one
let's
last
see.
question, if I could.
Sure,
Mr.
go ahead,
Chairman.
Mr. Blake.
Mr. Sullivan, in doing this, are you converting this to a record lot as a matter of right, or is that not a factor here?
It will have to be, yeah, there's no underlying record lot, so they will have to convert that to a record lot, which DOB does as a matter of right when they have an existing tax lot with a building and tax lot that have existed since prior to 1958.
Mr. Sullivan, did you, when was that provision put in requiring a record lot for permit? Do you recall what year when that was? Was that in 58 or was that in?
You mean like A301.4?
Yeah, requiring the record lot first. Do you remember?
I assumed it's always been there.
Okay. I'm just trying to get a sense that if you constructed this without getting approval because it didn't need it at the time. But I'll follow up. Thank you very much.
Well, and there's a lot of discussion about non-conforming conditions, which both neighbors have as well on either side of us. But a 1958 base map shows this footprint as it is now. Maybe it was a roof and wasn't closed in. I suspect that's probably what it was. But the lot occupancy was the same as it is today in 1958 or 1959 based. So I assume it's 58 as well. So, and at any rate, we're asking for, the proposed situation to be considered regardless of what was there in the past or what the current condition is anyway.
Thank you, Mr. Sullivan. My goal was just to get a sense of the time frame that footprint exists, and I think you gave me that information. Thank you very much.
Okay. Maybe this is for the architect. Like, you guys went to the old Georgetown board, right? And you had to make some changes to get their blessing, right? And the old Georgetown board is not an easy board, right? And so what did you have to do? What changes did you make that they thought were necessary?
They were fine with the footprint. So on first level and second level, their only request and they really didn't discuss the window, if I recall, the at-risk window. So they were fine with the layout. Their only request was that it aligns more with, the design style of a sleeping porch. So that's where extra windows came in, and we went back and forth quite a bit, like I mentioned, of, we don't need all these extra windows, but that was their request. So we went through several iterations to see what felt right, and for both the clients and balancing obviously the OGB's requirements. So that was really the feedback we got.
Okay, that's one. Then the other, I guess, is Miss Bowler and Mr. Piva. Like and actually I'm trying to think who to ask of this. Those windows that are on your side of the home that would go facing into the new addition, what do they look out of now?
Okay, so one of them is my dining room window. Right now I'm sitting in my dining room here. I can turn it.
No, don't turn around. Don't turn around.
Okay, so I'm looking right into their screened-in porch.
That's fine.
That's my dining room.
One's the dining room window.
Second floor is my office.
Okay, second floor. So there's just the two windows?
The two windows, but these are two of the rooms that I spend most of my time in. And the 9 feet away, the screened-in porch, like I say, it has screens and it's mostly empty most of the time. And suddenly 9 feet away will be a real, a house, like a house, a new house.
I understand.
Yeah.
And so for the architect, again, and this is what Mr. Vice Chair Blake was kind of asking, those windows look into what on the other side?
So the windows you're talking about in the
kitchen window on the first floor, and then the office window on the second floor.
Yes. So on the existing, like the L part that was added at a later date that we don't know that timeline, somewhere in the late 50s. That first level is the kitchen. It's the window above the sink. And then above that is a window in their existing bathroom. That's the existing building.
No.
Pull
I'm
up
saying you don't, what were you going to try and pull up?
I was going to say, if we could want to pull up the drawings again, I could point that out.
Is it in the presentation? Mr. Young, if you want to pull up the presentation and just, which slide it is, Ms. Cullen?
Yeah, it's going to be the proposed floor plans. So, yeah, earlier on. Okay, so that's the second level. So we can see that the office windows look.
Give me a second. Which slide are you on? You don't know.
Slide 15.
Slide 15. Okay.
What's on the screen?
Yep. I'm just looking on my computer.
Yep.
Okay. Right. Okay, go ahead.
Yeah, so those office windows will overlook the property to the south, their second floor windows.
Yep.
Which I believe, and correct me if I'm wrong, I apologize. I believe that's an office space.
Yeah, no, that's okay. I mean, I understand what's on the other side, meaning in the 1359 home. I'm just trying to get an idea as to, are those, I see on that slide says bedroom window at 1359 and that arrow, but then are those the two windows, those two little bump out things?
Those are the brick sills from the windows.
Those are the brick sills from the windows. Okay. And so Miss Bowler, I'm sorry.
That's right.
Is it, so there's two windows on that side?
On my side?
Yeah.
There's more than that, but these are the only I'm just talking about the windows that I have a view of this addition. I have other windows that don't directly look onto this addition.
Okay, because I see two windows right here. That's what I was confused about. One window seems like it's right across from the walk-in closet, and the other window seems it's right across from where the office is.
That's right.
Are there two windows there?
Yes, there are.
Okay. Okay. All right, I can get further clarity also. Okay, Mr. Young, you can drop that slide deck. Okay. All right, so now what I'm going to do is I'm going to ask if you all have any questions of the applicant, and if the applicant has any questions of you. Okay. So let me first start with the A and C. Commissioner, can you hear me?
I can.
Oh, great. Commissioner, do you have any questions of either the Office of Planning or the applicant?
I have two questions for the, I guess the board. How frequently are we seeing rear yard exceptions and special exceptions to the property lot and the lot occupancy? I think that's really the question out there is we've got a lot occupancy and a rear yard exception. And can we talk about separating the two? The ANC proposed that perhaps building upon the current structure that's on the building and going up from there. I think you saw our submission.
Okay, I'm just trying to answer your question. Sorry.
Yep.
In terms of how often we see these a lot.
Yep.
Like I don't know the number per se or whatever it is. So that's to answer that number one question. The other one is that the application is the way the application is, and the applicant is here presenting whatever the applicant is presenting. So we wouldn't change. So they
And,
can
and
be separate.
I hear you, but I just want to make sure the board understands and OP and also the applicant understands what ANC did suggest, right? It's the lot occupancy issue for us, which addresses some of the window issues and the privacy issues. And I want to make sure that ANC resolution is clear regarding that. And given that how often we are seeing this, that we heard from probably 12 different neighbors because we're seeing so many people apply for exceptions to the rear and the lot occupancy. And that's where we came down with our resolution. And I understand where OP is, but I also think light, air, and privacy, as well as water flow, does matter. So I have no questions, but I did want to make sure people understood why the ANC came out where it did.
Okay. Okay. Thank you, Commissioner.
Yep.
Ms. LaRocca, oh, sorry. Go ahead, Commissioner Wright.
Yeah, I just wanted to ask the ANC commissioner to briefly explain that by building on the existing footprint, you would perhaps be solving some of Ms. LaRocca's concerns because it wouldn't deal with the window on the rear of her building, but you wouldn't be dealing with Ms. Bowler's concerns because you would still have a two-story structure that was 9.
Correct. It would
3
be
inches
blocking, it would privacy, air, light, and it's obviously the current structure that's on the property is already over the property, the lot occupancy.
Right, so it would solve some problems,
But not all, no.
Okay, I just wanted to clarify that. Thank you.
Yeah. Thank you. And
Hold on one second. I think maybe, Commissioner, if you could mute your line. Great, thanks. Mr. Smith, you had a question?
I just want clarification from the ANC. Based on what you're saying, is your recommendation to solve some of these issues is for them to go up in height? So to a third floor?
it is not. We support, and I apologize for the, I'm going to
I don't think it's you. I don't know why. I think, hold on one second. I think it's Mr. Smith. Mr. Smith, if you will mute your line while the commissioner is talking.
I'm on mute.
Okay, go ahead, Commissioner.
Okay, thank you. No, we support the opposition, right, which we state in our letter because of the lot occupancy and the rear yard requirements and that the structure is already over the lot occupancy requirements. If there is a compromise to be found to build upon 2 stories only on the existing structure. Does that clarify?
I think that clarifies it. I don't know if it necessarily solves a problem and creates another one when it relates to light and air.
Exactly.
But I did want to understand the position.
Yeah, and we support the opposition as the position. And thank you.
Thank you.
Okay, thank you, Mr. Smith. All right, Ms. LaRocca, do you
Yes.
have any questions of either the Office of Planning or the applicant?
So I guess my questions first would probably go to the applicant or the applicant's architect.
Okay, what is your question?
So my question is, I mean, everybody just summarily says, okay, it's an at-risk window, we're just going to cover it up. But nowhere in their presentation do they make any reference to what that means. I mean, that's a material change to my building, and I'd like a little bit of color on exactly what that means.
Your question, Ms. LaRocca, I'm sorry, is what?
So if permission is granted to them for these special exceptions and they proceed to build over my window, I'd like to know what construction materials would be used, how would they block my building, and how would I be protected when they're blocking my building?
Ms. Cullen, do you have an answer for that?
Sure. So we have not put together full construction documents yet because we're so early in the process, but we would need to follow all of DC permit requirements. That would be a firewall, so we would need to maintain the fire rating between those two units. That information could come later with our assembly sheet. Mr. Sullivan, do you have any other further experience with at-risk windows that you feel like would be relevant here?
Not being expert in building code, in my experience with DOB, DOB will require that a person with an at-risk window close their window when a building comes within the limit of what it's supposed to be in proximity to that window. However, I think because the applicant's going to be like double fire rated, that precludes that from happening. That's all construction related wise anyway.
I'm sorry, sir, I don't understand what that means. So because it's double fire rated, I wouldn't have to go through the expense to close it from my side? I don't know what you're telling me.
Ms. LaRocca,
I can't give you advice on building code.
I'm not asking for advice, I'm just trying to understand the facts.
I'm also trying to real quick. I don't know if Mr. Sullivan, you're saying you know the answer. I don't think you know the answer. I can't recall.
I don't know the answer, nor is it relevant to this case.
I can't recall what has happened in the past when we've been in this situation. And so you don't know in the past what happened to somebody's window. Is that what you're saying?
Well, and I can give you a full explanation of what happens in the context of a BZA consideration of a special exception or a variance with at-risk windows. But if we're talking about building code,
I can find out the answer myself. I was just curious if you knew, and so you don't know what happens to the other side.
Construction-wise, I don't.
Okay, that's fine.
Yeah, thank you.
Okay, so Ms. LaRocca, yeah, I can find out also because I'm kind of curious because we've been in this situation before, and I don't remember what happens to the person next door, right? Yeah. And I don't know how much that cost is or isn't, and what we have ended up doing as a board, and I can kind of look into that a little bit more. Do you have any further questions, Ms. LaRocca?
No, I don't.
Thank you. Mr. Piva, do you have any questions of either the Office of Planning or the applicant?
No, sir.
No, not at this time. Thank you.
Okay, thank you. Thank you all. So, Mr. Sullivan, you will have an opportunity for some rebuttal, and then the parties will have an opportunity to, again, question anything you say in rebuttal. And so I want to mention to the parties, this is only questions on this point. They're not further questions on what happened before. It's just anything now the applicant might offer in rebuttal. Mr. Sullivan, do you have any rebuttal?
I do.
Okay.
Mr. Chairman.
Sure. Go ahead, Mr. Sullivan.
Okay, so in response to ANC saying 12 different neighbors are opposed to this, only 2 property owners can even see this addition or can even be slightly impacted by it at all. And what followed from that was more a discussion of macro zoning commission issues. They just don't like special exceptions. They think too many of them are granted. And of course, that's not applicable here to this specific case. My best rebuttal is going to be focusing on our case and the criteria Regarding light and air, the sun study is conclusive, as
Mr.
you would
Sullivan?
expect. Yes.
I'm sorry to interrupt you. I just want to make sure you're going to get a conclusion.
Yeah.
So I'm just trying to understand what's rebuttal and what's conclusion.
Okay. So then I'll for rebuttal, I'll talk about at-risk windows. This board has had at-risk windows in play before in special exception and variance applications. And what this board has found is that the at-risk window is not up for consideration. And here's why. It's based on a basic principle. If Ms. LaRocca could prevent the applicant from exercising their property rights and pursuing the use and enjoyment of their property because of her window, that's what's called a negative easement. She has a negative easement, and a negative easement by law cannot be created by prescription. It can't just happen. It has to be explicit by agreement. And from this principle, the DC Court of Appeals decision Hafazi-Stiglitz stated this, and I'll quote, "This rule flows from the basic principle that the actual enjoyment of the air and light by the owner of the house, Ms. LaRocca, is upon her land only, and that the owner of the adjoining lands, the applicant, has submitted to nothing which actually encroached upon his rights." So they can't lose their property rights by virtue of her putting a window on their property line. And so that's the basis for that. I mean, think about it, like if I want to put an at-risk window up, I can't. That doesn't mean that now my neighbor can't enjoy the rights of seeking special exception relief. There's been several cases. We did a special exception case 19586 7 or 8 years ago now, maybe 100% rear yard special exception blocked 10 floors of apartment windows on a building, including removing bedrooms. That was okay. Went to the Court of Appeals. The Office of Planning wrote a report on that in support. Case 18878, similar situation. There was a Court of Appeals case on that as well, confirming that. And so the board considers at-risk windows under that law for good reason. Regarding privacy, again, and I've conferred with my client on this as well, absolutely willing to do frosting, in particular because of some comments that Ms. Bowling made in her submission stating that she looks out upon the applicant's property dozens of times a day, and this proposal will alter her experience of gazing on the applicant's property. So absolutely would like frosting. The applicant wants to do that anyway. They were going to do it anyway. So we offer that as mitigation for the for any privacy concerns. And I think that's all I have for rebuttal. Thank you.
Okay, thank you. Does the board have any questions concerning Mr. Sullivan's rebuttal? No. Does the ANC have any questions concerning rebuttal?
No.
Miss LaRocca, do you have any questions concerning rebuttal?
I do. So my question for Mr. Sullivan would be, are all at-risk windows considered the same? Certainly the first case that you mentioned, I've actually read because that was in the record, and that was for new construction. So I'm curious to know if there would be a case out there where a historic window in a historic building was built before there was a lot line between the two properties, because your client's property was built as an addition to my property. Does that have the same standing as a modern at-risk window?
Yes, absolutely. There's nothing in the in historic preservation law that would change that basic principle that you're not entitled to a negative easement to look out over a neighbor's property and to keep them from exercising their property rights.
But I can get a reverse negative easement imposed on myself, effectively, by their
I'm sure
building
I
up against
understand
my
that,
wall.
that
Well, I
question.
mean, isn't that also a taking, I guess? If they take my window away, isn't that a taking of some sort? I don't,
No.
I'm practicing zoning law without a license, so I don't
Yeah.
really know the terminology.
Right.
But
Well,
that seems to me inconsistent. But that's it.
Okay, Ms. LaRocca, thank you. Mr. Piva, do you have any questions about the rebuttal?
At this time.
Okay, thank you. All right, I'm going to go through conclusions here. I do have something that I want from the applicant, and so, but we'll go ahead and do conclusions first. Commissioner, you want to go ahead and give us your conclusion?
Lot occupancy and rear yard exceptions should be exceptions, and they should be taken seriously. If light, air, privacy, and windows are impacted, they're used very frequently, and in this case, there is question as to whether or not the rear yard exception, the property lot exception, the light, the privacy, the requirements are met to provide approval for this. And all the neighbors opposed it as a result of looking at whether or not the requirements are met. And I asked the board to think about, are the requirements met for both of those, given the properties surrounding it and the opposition in the A and Z position?
Okay, Commissioner, thank you. Ms. LaRocca, would you like to give any summary?
No, I just would restate what I've said all along, which is I think their proposal to both violate the lot and occupancy requirements and then build up along my at-risk window I continue to be in opposition to that.
Thank you, Ms. LaRocca. Mr. Piva, would you like to add anything at the end, or conclusion, I should say?
I would just like to reemphasize that if you think of 2728 as an L shape, the foot has always been close, 9 feet away, but that portion is behind brick for me. So this addition that they're putting on, which is the part of their house, the biggest part that I look at all day on every level of my house, it will be like they're building a new house right there. That's all I can say. It will change my experience of my own home. Thank you.
Okay. Thank you, Ms. Bowler. Mr. Sullivan, do you have anything you'd like to add, or not add? Is there any conclusion you'd like to give the board?
Yeah, so I will be brief. So special exceptions are part of the zoning regulations. They're not outside the zoning regulations. And the board must grant when we meet the criteria. Very simply, we safely meet this criteria. Light and air, shadow studies conclusive. That's easy. Privacy, no change as OP noted from privacy, but if there are any privacy concerns remaining with the board, the applicant's willing to frost the windows. And on that point too, part of the applicant's wall with the window is already 9.3 feet away. I think that keeps getting missed. The sun porch is only a portion of the property that's at that rear line. It's the applicant's building that goes in an L and comes out to the 9.3 feet. So we're filling in a notch of the applicant's building, not a notch in the block. And you can nod your head, but that's a fact. And the board can go back and look at that.
You would like to come over. I welcome you.
We could bring up
Mr. Sullivan,
okay.
Please just have your conclusion, and please just have your conclusion.
Okay, so finally, it's barely, as I stated in the PowerPoint presentation, I didn't lie about that. It's barely visible from O Street, and it's approved by OGB. And I think that's it.
Okay, thank you.
Thank you.
Okay, so let's see. I would like to see this from the applicant. I don't know if my board has anything else they'd like to see, but if I could see something, I'm a little confused as to, again, what windows on 1359 are looking at what they're looking at, right? And so I'm looking at the architect. If you, and then Mr. Sullivan, if you guys can give me something just that I just can't visualize what those windows are looking at. And then you guys were talking about a frosting possibility, or Mr. Blake was talking about frosting. And so Mr. Sullivan, if you could, talk to your client and figure out what frosting where might actually help against those windows, that would be something I'd at least like to take into consideration, right? And so how long do you think that would take to get? Oh, I'm sorry. And does my board have anything else? Mr. Blake, you had your hand up.
I was really curious, is there something from the OGB, a report from OGB available? Mr. Sullivan?
I don't know. If there is, I can provide it. I'm not sure what they issue when they do conceptual approval. I don't know if there's a transcript or an order or not.
We have
Maybe
a-
Ms. Cullen knows.
Email trail, yeah. So the first time when we presented, we had comments and then we went back and forth with the board chairman and essentially provided a facade that they approved of, and we essentially got that via email. The approval via email.
Okay, thank you. I would appreciate that information just so I have something in the record with regard to that, because we have leaned on that a couple times.
Okay, if you could submit that into the record, then we can take a look at that. And then I guess again, Mr. Sullivan, those something that can kind of make it easier for me to conceptualize the windows on 1359 and what they look at and what you guys might frost on the other side. Okay. And again, whether or not we think it's necessary, that's a whole other thing, because I don't know if we've even gotten to deliberations as to what we think, but I just kind of like to have that information. Does anybody else from the board want anything? Okay, then Madam Secretary, if we do those things, when could we get back here for deliberation?
Did I hear if there was a time frame for the applicant? I'm not sure. You had.
I don't know, Mr. Sullivan, when you think you might be able to get this?
I'm guessing by Friday. Is that correct, Kylie? Friday?
Yeah, that's doable.
Okay. All right, then if we get stuff by Friday, then everybody would have a week to respond, right? Is that how that works?
Correct.
Okay. So what that means is everyone who's a party, ANCs and now new parties, would have comments to whatever gets put into the record back by the 18th. Okay. And then
The 18th or the 11th?
I think it's the
oh, I'm
11th.
sorry. I'm at the 11th, right? The 11th. Sorry. And then oh, Commissioner Wright's coming back anyway on the 23rd.
That's what I was gonna say. If we could schedule it for the 23rd. I could definitely be at that meeting for this case as well.
Got it.
Commissioner Hill, or Chairman Hill, we as ANC 2E do not meet until the end of April. So we actually will not be able to get an ANC comment if you do want it. We have a public schedule that we set at the beginning of the year, and we cannot meet outside of that at this point. It's too short of a notice.
Got it. You guys aren't meeting in April. Is that what you're saying?
We're not meeting till April 28th.
Okay.
Yep.
Okay. Well, I'm looking at my fellow board members. Okay. So I don't think anything's necessarily going to change with your recommendation, Commissioner. However, what you're going to get, and I think Commissioner Lose, did I lose you?
I think my internet's not so good today,
Okay,
so I'm
no
trying to
problem.
stay off
No
video.
problem. Okay, you can stay on video. Sorry. So even if we did, so if you met on the, so what I'm trying to get is like, we're looking for the Windows things and then possible shading. Can you all hang on 1 second? Sorry, somebody's at the door. Sorry. Okay. So we would be back here deliberating on the 23rd. If you all meet as an ANC on the 28th, if you gave us comments, and I'm just looking here, if you gave us comments, you think you could give comments the next day, Commissioner?
Sure.
It's possible. Okay. All I'm trying to say is like I don't think we're going to get anything new necessarily. The only thing, because we're talking about like I mean, you're not going to change your report. You're basically we're talking about
No.
frosting and what the view may or may not be. I got you, Mr. Sullivan. Hang on a second. Okay, go ahead, Mr. Sullivan.
Since we're not talking about changing opinions or anything, and they're just going to respond, I think the ANC's or Commissioner Lowe's is authorized by the ANC to speak further for the ANC. So I don't really think they need a separate meeting. I just don't, since we're going to wait forever for a full order. So I don't want to extend this time for decision more than it has to.
Mr. Sullivan, I got you. I'm looking to see what my board has to say about that or what we're actually doing. And as you said, it is going to take a while anyway. I don't see another week necessarily doing a whole bunch of difference to me. But go ahead. I'm looking to my board. If y'all think we should wait longer until the 30th, I mean, we're talking about another week, right? If the ANC wants to submit something into the record, which now that I'm talking it through, I don't mind waiting one more week. But do my fellow board members have an issue with waiting a week? Okay, great. So then, Mr. Sullivan, if you want to go ahead and submit whatever you want to submit by the 11th, okay? I'm sorry, the 4th, which is in 2 days. And then the parties will have until the 11th to respond. And then we'll keep the record open just for any ANC comment until the 29th. So, Commissioner, if something happens in that meeting on the 28th that changes anything that you submit, we'll wait until the 30th to deliberate. Okay, Commissioner?
Yep.
Okay, great. I got a thumbs up.
I'm
Ms. Wright?
available on the 30th. I would have to come back on April 30th. But I ask if it could be the first item on the agenda, because I do have some commitments later in the morning.
Okay, thanks, Commissioner. I forgot that you have to come back again. So we will do this first thing in the morning on the 30th, as well as the other first thing in the morning you got to do on the 23rd. Okay? Okay. All right. Madam Secretary, is there any questions to the deadline? Do you want to repeat what I said, or what do you want to do?
You're asking for submissions from the applicant by April 4th. Party responses from parties by April 11th. The ANC has until
Let me just raise my hand. Sorry, I'm going to raise my hand. Mr. Sullivan, do you just want to go until the 11th? I mean, you don't need it if you want more time to put this together.
Well, we might as well if it's
Okay,
all the same to everybody
Let's
else.
go ahead. Let's go ahead because it doesn't change anything in terms of the deciding factor. We'll give you until the 11th to come up with what we're talking about. Okay. Then the parties will have until the 18th to respond. The ANC will have until the 29th to submit something to us, and we'll come back here for a decision on the 30th. Okay. Does anybody have any questions? Okay. Madam Secretary, do you have any questions? Okay. Okay, great. We're all going to take a lunch break. And before I let everybody go, Mr. Sullivan, are you on with us the next one?
I am, yes.
Okay. Let's all have lunch. Okay. Let's all take a nice lunch break. Okay. And so let's come back at 1:35, 1:40. I'm looking at my board members. 1:40. Okay, 1:40, 1:45. Let's take 1:45. All right, I'm going to close this hearing in the record. Thank you all very much. And we'll see you back here at 1:45.
While we're waiting, Fred, I have a question. If I wanted to get information from the BZA's legal staff on a point, how would I request that? You're muted. I can't hear you. No,
Can
I
you hear me
can't.
now?
Yeah,
Do you have my number, Gwen?
no.
Okay. Give me a second, okay?
Mhm.
Hey, Gwen, I'm giving you a call right now.
Okay.
Madam Secretary, can you hear me? Great. You want to call us back in and call our next case when you get a chance?
The board is back from its lunch break and is returning to its hearing session. The last case in the agenda is application number 21263 of Susan M. Tamburini, trustee. This is a self-certified application pursuant to Subtitle X, Section 901.2 for special exceptions under Subtitle D, Section 5201 from the lot occupancy requirements of Subtitle D, Section 210.1, the building area requirements of Subtitle D, Section 5003.1 to allow an accessory building with a building area greater than 450 square feet, and the accessory building location requirements of Subtitle D, Section 5004.1A to allow an accessory building in a required rear yard. This is for a new accessory structure, a deck and a pergola in the rear yard of an existing two-story detached principal dwelling. It's located in the R1B zone at 4632 Charleston Terrace Northwest, square 1368, lot 54. And I'm sorry, my 4-year-old is homesick, if you heard that. As a preliminary matter, there are 2 motions from the applicant to waive the filing deadline. One is to allow in a shadow study and plans and exhibits 20A and 20B, and another to allow in a photograph and renderings that are in exhibit 31B.
Okay, thank you. Unless my board has any issues, I want to go ahead and allow those items into the record so we have a full and complete record and have an opportunity to look at them. If the applicant could hear me, if they could please introduce themselves for the record.
Thank you, Mr. Chairman and board members. Marty Sullivan with Sullivan and Barrows on behalf of the applicant.
Thank you, Mr. Sullivan.
Yes.
Ms. James?
Oh, sorry.
That's okay.
Yes.
Yeah,
Ms.
I'm
James.
sorry, Mr. Chair. The owner's with us, Susan Tamburini, and the architect, Tony Darrow.
Gotcha. Thank you, Mr. Sullivan. Give me one second, Ms. James.
Sure.
Ms. Tamburini, you want to go ahead and introduce yourself for the record?
Yes, I'm Susan Tamburini. I'm the owner of 4632 Charleston Terrace, and thank you for hearing my case.
Okay, thank you. And Mr. Sullivan, the architect, is that Mr. Deriro?
Yeah, Darrow, D-E-R-R-O.
Mr. Darrow, can you hear me?
Sorry.
Yes, I can.
Could you introduce yourself for the record?
Yes, I'm Tony Darrow. I'm with Aperture Architecture.
Okay, great. Ms. James, can you hear me? And if so, could you introduce yourself for the record?
Yes, I'm Deborah James, and I'm at 4634 Charleston Terrace, right next to the applicant.
Okay, great. Perfect. Okay, so everyone, if you could mute yourself unless you're talking, that would be helpful. And then what we're going to do again, Ms. James, is the applicant will have an opportunity to give their testimony. You will then have an opportunity to give your testimony. The Office of Planning will have an opportunity to give their testimony. Then the board will ask questions of whomever they want to ask questions of. And you, Ms. James, will have an opportunity to ask questions of the Office of Planning and the applicant. And then the applicant will have an opportunity to give any rebuttal. And then you and the board also will have any questions just on rebuttal. We won't revisit whatever happens before. It'll just be questions on rebuttal. And then you'll have an opportunity to give a conclusion, and then the applicant will give a conclusion. And during all this testimony, we'll be able to kind of figure out where we are with this particular application. Mr. Sullivan, if you want to go ahead and walk us through your client's application and why you believe they're meeting the criteria for us to grant the relief requested, I'm going to put 15 minutes on the clock just so I know where we are, and you can begin whenever you like.
Thank you, Mr. Chair and board members. I was going to do the main presentation myself, but Ms. Tamburini and Mr. Darrow are available for questions. If you could load the PowerPoint, please, Mr. Young. Thank you. The address is 4632 Charleston Terrace Northwest. Next slide, please. Applicant's proposing to replace an existing deck with a covered deck on the lowest level. According to the zoning administrator, the new deck is considered an accessory structure because it's covered, but it's also not meaningfully connected to the principal building. So it's not an extension of the building like a deck, like an uncovered deck would be. or like a connected portion of a building would be. So for that reason, this deck is an accessory structure, just like a garage would be considered. And the proposed covered deck is within the required rear yard, so necessitating special exception relief from 5004.1A. And the deck counts towards lot occupancy for the property. And so we're asking for relief of the 40% limit to go to 49.3%. And then the deck's also subject to the accessory structure maximum footprint of 450 square feet, for which we're asking for relief from that to go to 652 square feet. And all three areas of relief are considered under the special exception criteria 52001, the light and air, privacy, character scale, and pattern test. Next slide, please. The Office of Planning recommends approval, and they made a suggestion that the applicants consider screening in response to the party opponent's concerns, which we have done in the filing yesterday, and which you'll see in the PowerPoint, or on Monday, sorry. ANC 3D has taken no formal position due to a split vote, but they did submit a letter explaining each side's position. And there are 2 letters of support from surrounding neighbors, including the adjacent neighbor to the east. Next slide, please. I'll go through the criteria real quick before we get into the materials. We meet the general special exception criteria. The property's remaining single-family detached dwelling. Proposal is not increasing the size of the existing principal building, and all of this is within the special exception criteria. Next slide, please. The deck it's open on all sides. The shadow study shows no undue impact on neighbors' light and air. There's no impact to the buildings to the south, and minimal impact to the west, to Miss James' property, but not undue. And there are 3 windows facing north from the condo building to the south. And I'll show you on diagrams that 2 of those windows are safely below the floor level of the proposed deck, and they currently look out at a large retaining wall on the client's property because of the slope of her property. And then there's just 1 window on that building that is above the floor level, and it's offset from the property. It's actually adjacent to Miss James' property, and we'll show you a photo of that relative distance there. And of course, the addition is not visible from any public way because there's no alley here, and it can't be seen from the street. Next slide, please. There you see a map of the property, and the buildings south of this, or southwest of the property, are apartment buildings. Next slide, please. There's an overhead view of Ms. Tamburini's property. You can see the current deck there. Next slide, please. So this is the rear of her property. That's the retaining wall I mentioned, and there's a fence there. So the lower windows currently look at this retaining wall and fence. The lower windows on the apartment building to the south. Next slide, please. This is the existing deck. Next slide, please. Also more of the existing deck and an outdoor patio space. Next slide, please. Next slide, please. And this is a view looking east from the applicant's property. Next slide, please. So this is a photo that was actually in the submission by Ms. James, and I thought it was helpful to show the windows. So those 2 windows there are below the level of the proposed deck, and I'll show you that on a different graphic. So leaving the only window being that small window on the upper level there. And this photo looks out from Ms. James' property, and you can see the fence line there. So it's offset 8 or 10 feet from the subject property. Next slide, please. This is a plat showing the deck addition in the rear. Next slide, please. So this was filed as a page. We blew these up for the PowerPoint, so the next few slides are going to be these renderings blown up a little bit. So next slide, please. This is the site plan showing the deck. So you see the window noted on the south building there to the left, and the distance between the deck and the configuration of it in the context of the condo building to the south. And Miss James's building is on the left. Next slide, please. There's the level of the windows. The lower window in the south building, which Miss James called French doors. They do look like that, but they're windows with a balcony. But at any rate, they look out. They will be, after this proposed, they'll be well below the floor level of the proposed deck. And the other window is at that level as well. Next slide, please. This is similar drawing showing the relationship of the window to the proposed deck. Next slide, please. And here's a rendering showing that. So the window in the back, those two windows in the back are the ones that aren't directly adjacent to the subject property. They're more adjacent to Miss James' property. And the first window you see is what Miss James described as the French doors. Next slide, please. There's an overhead rendering showing the proposed deck. And we mentioned it's a proposed deck and pergola. The pergola portion of it is in the middle of it, and that counts in the lot occupancy because the slats there of the pergola are closer than 24 inches apart on center. So that's all, the entire structure is included in the proposed lot occupancy. Next slide, please. This shows the footprints of the existing deck versus the proposed footprint of the new deck on the right side there. Next slide, please. Just another overhead view. Next slide, please. And there's a rendering from the other side. This isn't formally proposed, but Ms. Tamarini intends to have greenery on that side of the deck and planters for additional coverage or screening from the building to the south. Next slide, please. And here's a view of the same thing from the west. She's also intending to have greenery on that side as well, including that tree. Again, we're not proposing that because I think that's hard to enforce and it's a little more ambiguous, but we did propose very specific screening for this side of the deck, which we'll see later on in the presentation. Next slide, please. These are the shadow studies. So the areas outlined in orange are the additional shadow from the deck. It's done from, rather than from matter of right to proposed, it's existing to proposed, because the deck is not covered now. So next slide, please. And these are just different times. You see the amount. The Miss James building is over to the left, so there's a little bit of impact on the left side there, noon in the spring and fall. Next slide, please. Next slide, please. Next slide, please. Next slide, please. And if you have any questions about any particular slides, please let me know, but I'm going through these because since the area is outlined. Next slide, please. And that's probably the area of the most shade casted to the west. Next slide, please. Next slide, please. Next slide, please. So we did submit yesterday morning we took Miss James' photo of her view from the solarium and we superimposed the deck on that to get a sense. So I think we got a really good sense of the privacy and view situation of how it would look. And also we have two renderings that we submitted that are coming up to show the screening that we're proposing as well. I don't know if privacy is a major concern or not. And the Office of Planning raised the issue It wasn't discussed much at the ANC meeting, but if it is an issue, it's certainly, we wanted to propose this because we think it's nice screening and fits in well with the deck. Next slide, please. So there's the view. This is the photo that Ms. James provided from her solarium down at the existing deck. So there's already a deck there and already outdoor recreational space of Ms. Tamburini's. Next slide, please. And this is one thing Office of Planning noted, that covering that deck actually improves the privacy situation over the existing. But in addition to that, so we have the screens here provided, which you'll see later in a rendering, because that'll be easier for the zoning administrator to use to approve a permit, but wanted to show you this view from here. And those screens go all the way up because there's some shade there. You can't see that, but they go the full length of the deck. They're going to be 3 feet wide each, and we're proposing to put them anywhere on that side, because I think anywhere on that side that you put it, it's going to have a significant increase in the privacy between the two properties. Next slide, please. So here's a rendering of how the slides will look from the inside. Next slide, please. The screens. And that's a rendering showing them from that angle as well. So I think the screens are of more effective and more attractive than what you're used to seeing when we're screening a deck. And I think that fits in line with the design of the deck. And also, if there are privacy concerns, I think that would do a really good job of mitigating those. Next slide, please. And that's it. If the board has any questions for myself or Ms. Tamburini or Mr. Darrow. Thank you.
Thank you, Mr. Sullivan. Thank you for your presentation. Ms. James, can you hear me?
Yes.
Okay, great. So they went about 15 minutes or so. So you'll have the same amount of time if you like, and you can go ahead and give us your testimony.
Okay. Thank you for hearing me. I want to state up front, well, first, I just want to state up front in general, I want to say to Susan that regardless of how this comes out, I am your good neighbor. I want you to know that. If there's ever a time you want to feel you want to draw on me as a neighbor, I'm going to tell you if your garage light is on when you don't know. I just want you to know that however this
Ms. James,
yeah.
Ms. James, I'm going to interrupt you 1 second. I really appreciate what you're trying to convey, but then what's going to happen is people have to respond to whatever you're trying to convey. It's okay. It's
I'll
okay.
just get to the point. Okay.
I appreciate it, though.
Okay. So then I also want to say that if this were just a deck, if this were just an extensive deck, I can't imagine having any objection. In fact, I'd probably give a level of support. I most definitely want Susan to have access to her outdoor space. So just so it's clear, my concern is with the roof. And I think that's why it was designated as an accessory structure. And I do want to make sure that as you walk through it, as decision makers, you keep in mind this is an accessory structure that I gather in consultations with the zoning administrator, it was determined to be that. Now, it might be somewhere earlier in the file, but the first time, I'm new to this. I don't really know this process, but the first way I became aware of that was a footnote in the OP report. And then indeed, it was referenced up front now in applicant's presentation. It just rings to me. I'm just curious. It's a question. Apparently, there was some preliminary consultation with it sounds like with the zoning administrator. I don't know if that's typical. I didn't see, maybe there in the file a reference from the zoning administrator, but I don't see that. So I just want to make clear that while there may be a process to follow if this were just a deck, I want everyone to keep in mind this is an accessory structure and to review it with that concern. So, and I also want to say, I know certainly that applicant is fully within her right to request these exceptions. But indeed, there are exceptions. I would like to think that the zoning regulations afford us some level of protection and that when exceptions come up, they are looked at carefully to make sure, of course, that the criteria are met. So starting with the criteria of being in harmony with the intent and purpose of the zoning regulations, I think this is a case to look at that very carefully, that it's not as simple to say this is still a single family home, that it maintains that overall structure. That I accept, that is true. But I think the zoning regulations go beyond that in its protections. And in this case, I think the concept of putting in an accessory structure in a space where a backyard that wouldn't fit by right, as I understand it, any accessory structure, even to ask, that is, if I understand this, by right, an accessory structure would have to be 25 feet beyond the main structure. So that I'm just saying it's hard for me to imagine that the you're in harmony with the intent and purpose of the zoning regulations to completely basically block off your backyard with something that by right, just to do it by right, you couldn't put in that space at all, and that's all there is back there. That is, you go back more than 25 feet, and I don't think you're even still on the property. So I do ask the basic question, even before you get at the question of harm to individual property owners, neighboring property owners, whether this really is overall in harmony with the intent and purpose of zoning regulations for not just it's not even a regular size. So keep in mind it's an accessory structure that by right should be 25 feet out. Here they're looking to put it 18 inches from the main property. It's not even saying, well, 20 feet, 15 feet, 10 feet, 8 feet. 18 inches. So that's really close to the main property. And as I understand it, an accessory structure by its nature doesn't have to can waive set off rules. They can go closer to the adjacent property lines, and that might have its rationale if it's 25 feet out. I don't see the rationale for waiving set off if you're 18 inches from the main property, and the result will be, because they're going to push, if I understand it right, 3.77 feet from my property line, which will make the beginning of this new structure even closer to my home than her home is right now. And of course, the reason it's coming so close and occupying so much space is she's looking to make it 44% larger than a regular, than a by right accessory structure, 200 feet larger. And that the overall result is that she's getting very close to the 50% on the occupancy, all of it concentrated in the backyard. Tending towards my property. I just ask it's this overall question to look at each component carefully. Is this really in harmony with the zoning, the intent and purpose of the zoning? In keeping in mind, these are very taut lights. These are lots. These, we're in. This is an in-city location where the houses are already as close as I think they can be in this zoning. So they're tight lots. They're tight. It means that yes, looking out the window right now, I see applicant's house, and that's the point. You do see other houses, and that's why the remaining open space really is precious. And I say that not just how it impacts me or other neighbors, but simply as an overall zoning concern. Moving specifically to my situation, I actually would like to pull up. Is it Mr. Young? Can I ask Mr. Young to pull up um, applicant's markup of my picture? I think it's in Exhibit 31B.
One second, Miss James. Yeah, Exhibit 31B.
I think
Okay.
that's what it is. It's the color photos. It's the markup
Yeah.
of my photos.
Mr. Young, do you see 31B?
Okay. So first I'd like to say this, yeah, okay. This one, I don't captures the flavor so well of how much of an impact it's going to be. But if you scroll down, scroll to the end of this, let's go to the next one and I'll make some comments. Then after this, there's another one. Okay, so this one to some extent does, but this is going to, I think, if I look at the, if I like peer down, I think that her structure is going to be still closer. So it will have even more of the sense of going directly into her. There's, I think, this to me, like if you look down, it looks like it's more than 18 inches. Very, very quickly, you'll reach the vanishing line where you don't see the difference between where this property is and her house, much closer. So I'm saying we'll have somewhat of this effect. Frankly, this occupies a lot of space. But it will have even more so because it will come closer to her house. So there'll be even more of that. And what gets a little confusing in this picture is, remember, her accessory structure is now going to come even closer to my house than my property line, and in turn my house than her house is. So on this picture, the depth is a little confusing to see. So you have to visualize that indeed her house is very close, and indeed this accessory structure is going to be some 4 feet closer, as I understand it. So looking at this picture, I think the accessory structure itself will come closer to her property than is properly represented here, and will, as I said, depth is hard to reflect, but I'm just pointing out it will come even closer than as close as her house, and her house is very close. I also want to point out as a detail, because as we've said, plants are ephemeral, but that tree certainly is not there now, a tree in exactly that position, like that, in that position, at that height. I don't know whether she plans to put such a plant, but of course, even if there is such a plant, plants can come and go, and it would only have leaves and flowers at certain times. But I mean, looking at that picture, frankly, it occupies the remaining open space. It means I will see, looking from my sunroom, I will see roof. And as I said, coming even closer to her house than I think this represents, and closer to my property, as it'll be 4 feet closer than uh, her house is now to my property. Okay, I just wanted to show that, so I would give my view on that. So, I mean, it will.
Thank you, Mr. Young. You can drop that. Thank you.
So it will affect the it will affect the use and enjoyment of my property. It also has this impact on the condo owners. I don't know whether applicant has managed to speak to the condo owners. I have been in contact with the condo owners, and I have made them aware of my filings. They've expressed that they are so busy that they have not really been able to focus on this, both in work and outside of work. I'm not sure if they're on this call now. I've spoken to the husband, and he said either he or his
Miss
wife.
James, can you hang on one second?
Yeah.
Mr. Young, could you drop that slide deck for me? Thanks. And Ms. James, I'm never sure exactly how this works. Like, you can provide testimony as to what you have done, but you can't provide testimony for other people unless there was like some kind of like written thing that you had in the record that said you're allowed to provide testimony on behalf of somebody. But just go ahead and continue, please. Thank you.
No, I'm not providing testimony on their behalf. I'm just saying that I have been in touch with them. That's all, and that they might be on this call. They said they were going to try to be on the call. That's all I'm saying. Yeah. So I am happy that 3 members of the ANC were supportive of my position. I'm quoting from what they sent, which is an exhibit in the record. They wrote, in combination, these 3 deviations from normal zoning constitute a massive overuse of the backyard and an abuse of applicants' neighbors. The addition of the roof to deck, making it an accessory structure, greatly increases the impact of the proposed addition. In particular, the light available to the apartment building in the rear would be restricted, as would the air for the yard and the next door neighbors. Moreover, they suggest there are reasonable alternatives, and in fact, I do think it's possible for applicant and or architect to come up with reasonable alternatives. There's a statement in the OP report that I have to say I don't fully understand, to the effect that somehow it's not feasible to reduce the size of the deck because of existing site conditions, including drainage and retaining wall ties. I guess I'm a little confused by that, as in right now they don't have a massive deck, so I don't see why they need a massive deck for these purposes. Somehow it seems to me they could accommodate it. Otherwise, they could also potentially make the roof smaller. As I said, I actually have no objection to the deck. I want Susan to be able to use her outdoor space. So
Miss James, James, just to let you know, you're at 13 minutes, so you have a couple minutes left.
Right. I think, I don't know if I have that, I want to be able to enjoy my backward facing property. I think in general, we often think of our backward facing space as the more private space. And therefore that amount of open space in that direction is particularly valuable. This is a neighborhood where by its nature, you see, you do see neighbors, and therefore what the space that remains is valuable. I think it goes moreover just to the fundamental not in harmony with intent and purpose of the zoning laws. Let me see. Yeah, I think this is, I appreciate the OP report commenting to coordinate with neighbors. I think it should go beyond simply screening. I think it's possible for the applicant to consider possible designs that are less intrusive. And as I said, even at core, I question whether such a massive structure, meaning the roof, should even be there.
Okay, thank you, Ms. James. All right, before I turn to the board and everybody, can I hear from the Office of Planning?
Good afternoon, Chairman Hill, members of the board. For the record, my name is Philip Bradford, Development Review Specialist with the Office of Planning. The Office of Planning recommends approval of the requested special exception relief and stands on the record of the report in Exhibit 30. Thank you, and I'm available for any questions.
Okay, thanks, Mr. Bradford. Okay, Mr. Young, is there anyone here wishing to speak?
We do not.
Okay, all right. So now I'm to questions. Let me first look to, oh, go ahead. Did you have your hand up, Mr. Smith? Oh, okay. First, let me go. Ms. James?
Yes.
Do you have any questions of the Office of Planning or the applicant?
Will I have another, well, after, if they have questions, will I have a follow-up chance for questions? Well, I guess I do have this question, the question I just raised, indeed. What did applicant mean when they said to OP that it's not feasible to reduce the size due to existing site conditions, including drainage and retaining wall ties?
So that's, you're asking the applicant
I'm
that
asking the
question, Ms.
applicant
James?
that question. Yeah, because I
Mr. Sullivan, do you have any idea as to that, an answer for that question?
Yeah, generally. So the reason why that was brought up, because it's not, of course, it's not part of the special exception criteria on why we didn't do a different alternative, or whether we could or not. But in discussions with the Office of Planning, I told them that we would look into adjusting the deck or moving the deck, and that was the reason. Then I responded to OP after I heard back from Mr. Darrow and Ms. Tamburini that would be difficult to do and that they didn't want to do that. So
okay, so Ms. James, it doesn't seem like they were either able to do it or wanted to do it. Do you have another question, Ms. James?
Okay, I mean, I don't see that as a particularly thorough answer. I mean, this says
The answer, Ms. James, just to let you know, the applicant is here asking for what they're asking for.
Okay.
And so then the board is going to determine whether or not they meet the criteria for what they're asking for. So they can come ask, with the right to ask whatever they want to ask. And so that's what they're before us right now.
Okay. I want to know, has the applicant been in touch with the owner of the 3-panel French doors?
I guess
So,
can ask.
yeah, in addition to the regular notice, we did send out additional notices as we like to do when it's hard or difficult to connect with a neighbor. And so we did send them follow-up letters of notice and got no
Okay.
response.
Okay, and got no response. Okay. In the design, just a design question, isn't the deck itself continuous? It's the roof that's a little bit detached.
Your question is whether or not the deck is attached to the
Well, that
building?
is, as I'm seeing the design, I don't read designs all the time. I don't know just how to read them. It looks like you step out from the house directly onto the deck. The deck is not detached from the house. And that at some point in about 18 inches, the roof begins. So I'm really just asking for clarification. Is the deck continuous from the house? It's just that it's the roof that begins 18 inches in?
Well, sure. I mean, the deck is connected to the house. Otherwise, there'd be no way to get from the house to the deck. So
the answer is
there's
yes, Ms. James.
yes.
Right. Okay. So do I have more questions? These are simply questions. I guess those are my questions. Yeah.
Okay, thank you, Ms. James. Okay, I'm going to turn to the board. Okay, does my board have any questions for the applicant or the Office of Planning? Go ahead, Commissioner Wright.
Given the relief that is being requested, and given the interpretation of this as an accessory structure, what would be the steps required if in the future the owner wanted to enclose and make this conditioned space? Would they have to come back to the BZA or anyone else for any approvals? Or could they enclose this area and make it conditioned space, since they're getting approval for a number of different special exceptions for an accessory structure?
If my client asked me that question, I would say you definitely can't make any significant changes to anything that the BZA specifically approves like this. So it would remain, they would have to have the screens, they would have to leave it open, and any change at all significant to the deck is going to require modification of any approval.
Okay, but they are getting approval essentially for an accessory structure that is over the normal size limit for accessory structures of 450 square feet. They're getting approval for an accessory structure that is closer to the primary residence than is normal for a accessory structure. They are getting, a variety of approvals that, and, again, I understand you're saying that because we're approving this specific application, that they would need to come back if they wanted to enclose this area and make it conditioned space, but they already have their approval for an accessory structure over 450 square feet, etc.
Mr. Bradford, can you hear me?
Yes.
Yeah. So, Mr. Bradford, can you answer Commissioner Wright's question? I basically think, I can't recall exactly how it works, but it would change the whole dynamic of the project, and they would be back they would need a whole bunch of different kinds of relief to actually be able to do that. But Mr. Bradford, are you able to answer Commissioner Wright's question?
No, I'm not quite sure what would happen if they decided to enclose that in the future.
Okay, give me a second then again. Mr. Sullivan, you seem to think you have an answer?
Yeah, I mean, it's an automatic condition of any board's order that the project be consistent with the plans submitted and approved. So we submit those plans to the zoning administrator or to DOB with a permit application, and that's all that can be done. And if there's any other permit application down the road, they would see that it's BZA approved structure, and they would go back to those plans. So it's a condition of the order. I mean, it's a condition of every BZA order. You don't even have to do it specifically. Yeah.
In this particular case, I think it makes a huge difference. Would your client be willing to accept a specific condition that would say that this structure would not be enclosed as conditioned space in perpetuity?
Well, I don't know if that's appropriate or advisable that they would burden the property in such a way, because does that then mean, I mean, I think it probably doesn't matter because that's what they're stuck with anyway. I mean, one of the things on Monday, of course, as you know, the zoning commission eliminated this particular area of relief. So it doesn't, when that becomes effective, there's no limit to how close the accessory structure can be to the principal building. And of course, there's no side yard requirement for the accessory structure. So that location is, in a couple months, it's a matter of right. I know that's not this application. That goes more to spirit and intent argument, I think. But I just don't know the implications of, I guess so. I mean, because it's just the opposite. It's just the negative of what we're saying. We're required to do what's in the plans and nothing further. So yes, I don't see any reason why that would matter, because if they wanted to do something different, then they would absolutely have to go back. Well, no. So let's
It's
say
okay, Mr. Sullivan, I'm going to interrupt you.
It's a good, important point, Mr. Chair. They could remove the structure completely, and then we're starting from point zero. But there might be something on the record saying we can't do something, even though we could do it, or we could ask for relief from that. So I think it's a little cleaner if we leave it the way it's normally done.
Yeah, I think what I was going to ask, or I'm sorry, mention, Commissioner Wright, if you're interested, is that, we can talk to OZLD about this issue, and we can do that now if you want, or we can also do it after the hearing and before a decision is made. And I'm happy to go either way.
I would be interested in hearing what our legal staff has to say about my question.
Okay,
I don't know when the right time is, but I would be interested.
No, that's fine. Why don't we go ahead and continue moving along here, and then we'll come back and have an emergency meeting and talk to OZLD and then come back. Does anyone have any further questions of the applicant or the Office of Planning? Okay. Mr. Sullivan, do you have any rebuttal?
No, thank you, Mr. Chair.
Okay. All right. Then let's go ahead and do the thing real quick, the emergency meeting real quick. Let me get my little script. Okay. Okay. And just Miss James, can you hear me?
Yes.
Just so you know, we're going to go a step away to have an emergency closed meeting with our legal staff, and then we're going to come back, and then you'll have an opportunity to give like a 3-minute conclusion. The applicant will have the same time, and then we'll see where we get. Okay.
Sure. Okay.
Okay, we'll come back in a minute. Let's see. As chairperson of the Board of Zoning for the District of Columbia, in accordance with 407 of the District of Columbia Administrative Procedures Act, I move that the Board of Zoning Adjustment hold a closed emergency meeting on 4/2/2025 to seek legal advice from our counsel on application 21263 and deliberate upon but not vote on case 21263. Is there a second, Mr. Blake?
Second.
Motion been made and seconded, Madam Secretary. Take a roll call, please.
Please respond to the chair's motion to hold an emergency closed meeting. Chairman Hill,
Yes.
Chair Blake,
Yes.
Mr. Smith,
Yes.
Commissioner Wright.
Yes.
The vote is 4-0 to 1. The motion passes to hold emergency closed meeting.
Okay, great. All right, we're going to jump off of this one and jump on another one. See you guys in a little bit. Okay, Madam Secretary, can you call us back in, please?
The board is back from its emergency closed meeting with OZ Legal and is returning to application number 21263 of Susan M. Tamburini, trustee.
Okay, great. Mr. Sullivan, can you hear me? Ms. James, can you hear me?
Yes.
Okay, great. Ms. James, do you want to go ahead and give us a 3-minute conclusion?
Sure. Just one second. Let's see. It's not loading. Okay, 1 second. Wait, just give me 1 second. Sorry. Well, okay. So basically, we count on the zoning regulations to protect us. I ask the board to carefully consider whether the criteria for exception are met here. Our tight city lots are not designed to accommodate massive accessory structures. Do we really want our limited open space intentionally so set by the zoning regulations to be blocked by massive structures that are only possible with several substantial exceptions?
Mr. Chairman, can you hear me?
Yes, I'm sorry, Ms. James.
I'm sorry.
Yes,
I had a sound
that's
issue and my assistant told me that you had said something. So sorry about that.
got it. No problem.
I am here.
Okay, thank you, Mr. Sullivan. Ms. James, I'm sorry. Please continue.
And I think at a minimum, applicants should consider alternatives, less disruptive alternatives.
Okay, thank you, Ms. James. Mr. Sullivan, do you have a conclusion?
Yeah, thank you, Mr. Chairman. Very simply, the application meets the special exception criteria. There's minimal impact on light and air. It's not undue, certainly. Privacy, as OP stated, was improved, and then especially with the additional screening. And there's no visual intrusion because there's no view at all of this structure from the alley or from the street. Thank you.
Okay, thank you, Mr. Sullivan.
And also, we would be happy to agree to that condition too that Commissioner Wright mentioned. I don't think there's a material difference between. I don't know what the outcome of the meeting was.
I got you, Mr. Sullivan.
But yeah, we're okay.
That's okay.
I just didn't know. I think the word in perpetuity scared me, but it's not a covenant anyway. It's just the order. So yeah.
Gotcha. Thanks, Mr. Sullivan. All right, I'm going to go ahead and close the hearing on the record. Mr. Young, if you could please excuse everyone. Okay, thank you. Mr. Smith, I believe you were kind enough to begin the deliberation.
Sure. I'll begin the deliberation. So what was before us today was a self-certified application for special exceptions from the lot occupancy requirements, the building area requirements for an accessory building larger than 450 square feet, and the location of the accessory building in the required rear yard. Based on the submitted information within the record and the testimony provided by the applicant, I do believe that the applicants met the burden of proof for us to grant these special exceptions, and I will look towards the criteria under D 5201.4 for the reasons why they have met that requirement. What we're tasked with looking at is under D 5201.4 A, B, and C. Does the light and air available to neighboring properties, will it be unduly affected? I think based on the design of this particular accessory structure, given the topography and the design and size of this accessory structure, it would not have an undue impact on the adjacent property owner's light and air. This structure as designed would be open. an open structure that would allow light and air to traverse through the structure and would not impact adjacent properties. And also, I will state that the topography itself would lend itself to not creating a hindrance to light and air to any of the adjacent properties. The privacy and use and enjoyment of neighboring properties shall not be unduly compromised. Again, the crux of this of the impacts is undue. This is an accessory structure. There's a preponderance on the zoning ordinance to allow certain size of accessory structures within the rear yard. And again, this is an open accessory structure. So I do not believe it will have a substantial impact on neighboring properties. The proposed additional accessory structure together with the original building as viewed from the street, alley, or public way shall not substantially visually intrude upon the character, scale, and pattern of houses along the street or alley frontage. And as Mr. Sullivan stated, this is in the rear yard of the property, so it shouldn't have a visual impact as seen from the street, alley, or any public way. The standard special exception considerations, I believe that this structure would be in harmony with the general purpose and intent of the zoning regulations and would not, again, tend to generally adversely impact any of the neighboring properties. While going back to this concern about privacy, the adjacent property owner did state that they believe that this structure may have some material effect on their privacy, and the applicant has Ms. Wright has recommended a condition that would mitigate some of those concerns related to, sorry, not about privacy, but related to light and air. I welcome some additional dialogue from my board members regarding some form of a condition that would restrict any future enclosure of the accessory structure. With that consideration of a condition, I would recommend approval.
Okay, thank you. I guess, and we can have further discussions about this. I mean, like we could reference something in an order. This is going to be a full order. I'm not a big fan of that particular condition, just because I think that the way it needs to be built is the way it needs to be built. But I'm happy to continue that dialogue. Mr. Blake, do you have anything to add?
Well, first of all, I agree with Board Member Smith's assessment. I have a few other comments, slightly different direction, though. I think that the applicant has met the burden of proof in the sense that the issue, again, go with light and air. I don't think that there's going to be a material impact on light and airflow, and light particularly because of the location of the properties relative, as he pointed out. The privacy issue is something that was really curious to me, and it wasn't with regard to the property to the west from the party in opposition, but more so to the privacy of the condo to the south because of the downward look of the property. But in reviewing, based on the testimony I heard today, my concern is significantly reduced because the windows, there are 3 total windows exposed. Those 2 windows to the right are actually towards Ms. James' property. And the lower window on the side is so far below the retaining wall that it will not have an impact on the light. And I do not think the privacy will be materially impacted as well. It's a southward property, so there's no impact in terms of the sun. So I think that, and privacy is really not an issue there. So to the extent that we were going to include some type of privacy screening, I would have ordinarily said it would go to that side, not to the other, to the west. The issue with the west side, and the party in opposition made a very clear statement about this at the outset. Their concern is solely with the roof. They were completely comfortable with the size of the deck, but the issue was the roof. And it was largely because it had a visual impact on their line of sight from their sunroom. And reviewing those slides very carefully and hearing the presentation today, it was clear that the issue provided did actually, the roof did provide privacy for the subject property. The screening would provide additional privacy for the screening property. The view is what the concern was that was created by the roof. And that view is not something that we actually are focused on from our perspective. So for example, the zoning regulations in District of Columbia focus on control, land use, density, height, bulk characteristics of property. When a view is not protected. So there are no zoning regulations protecting individual view sheds. In the context of the special exception test, the board looks into consideration of the impact on the proposed project on neighboring properties that relates to light, air, flow, and privacy, which we've talked about. It also factors in a degree of visual intrusion on the character and pattern of housing along the streets and city and alleyscapes. Now, we talked about that. There's no visibility from the street or from the alley. There is no alley in this case. But it does not specifically address the visual intrusion of a person's line of sight being disrupted or obstructed by an unwanted visual element in their environment. In other words, the roof, you may see the roof, but it's not on your property. And we are not tasked with evaluating the adverse impact of what you consider to be an unattractive roof away from your property. So there are ways you can certainly address that. You can have an easement that says you can never build that, but that may be something you have to negotiate. But it's certainly, there's no restrictive covenant rely on that or anything like that. So we do not have that in this case. So in that regard, I'm not, the issue about the impact of the property to the rest is the property to the west, I'm somewhat less concerned with. So having said that, I do believe the applicant has met the burden of proof to be granted the requested relief. And I will be voting in support of the application.
Thank you. Commissioner Wright?
Thank you. This has been a very interesting case. I'm going to be voting against the application, not in favor of the application. I really am concerned about us proving an accessory structure greater than 450 square feet and or 30% of the required rear yard. It's significantly higher than 30% of the required rear yard, and it is higher than 450 square feet. I think that it is too big for this property, and I think that it will have a detrimental impact on the nearby neighbors' enjoyment and use of her property and the views from her property. So, you know I may be in the minority here, but I can't support the application.
Okay, thank you, Commissioner. No, I appreciate that. I guess on my side of things, I mean, just what I remember in the experience that I've had, the part that in trainings that I've done, it seems as though a view is something that we're not necessarily protecting. A view is not something that is within the scope of the regulations. Now, the size of something, the light, it goes back to, and I'll go back just to me again with the, I'm gonna look at the regs real quick again. Yeah, 5201.4. And the light and air, privacy and enjoyment, and whether or not you can see it from the street or the alley. As I guess I'm going to align my comment or my thoughts with Mr. Blake and Mr. Smith, and that I think that they are meeting this particular criteria. Press to grant the relief. I don't know about the screening. I don't, I guess Commissioner Wright's still allowed to participate in this discussion, even though she's not interested in this particular, or doesn't think it meets the criteria. But I don't know if the screening, I'm looking to the other board members, were you all saying that you thought the screening was serving a purpose? And if so, would it be the way that it was suggested? And I'm gonna go with Mr. Smith first.
I think it should be the way it was suggested in the plans, where they're proposing currently now for it to be completely open. So what we could do is we can forego the condition, given that the plans have showed substantial compliance. The plans show that it's open. So when they submit the plans to the Department of Buildings, it will have to be in substantial compliance with how we've approved them. So we could potentially just forego the condition and just trust the plans. And if they do not move forward with these plans as submitted, they would have to come back before this board.
What I meant, and I'm sorry, and what I was trying to understand was that there's the two screens that are on the side of the deck that is facing the party in opposition. And there are two screens, right? So those are the two screens that I guess, and I'm just for lack of, it seems like it's just as fine with me to approve it with the two screens on that side as not, because what Mr. Blake was saying is that the screens really would be on the side where the condo building is, right? Perhaps more importantly, particularly, and I can't get my head around exactly where that other window is. The one that is below the deck lines. I mean, they're below the deck line, but the one that was right over there by the condo building, that's a different screen. But I'm fine with keeping it the way the proposal is, which I think is the two screens on one side and two screens on the other side. I can't remember whether they were, no, it was just the two screens on one side. Okay, just the two screens on one side. And so, if that seems to be helpful to making the project more amenable, then I would be fine with that too. So I guess we're keeping this currently on the deck. Currently on this discussion are the two screens on the side that is facing the home in opposition. And Mr. Blake, are you on board with that?
I could support that. I don't think it's necessary, but I can support that. Yes.
Right. Okay. All right. Then I'm going to go ahead and make a motion to approve application 21263 as captioned and read by the secretary, and specifying that this is not a condition, but specifying that this will be built as per the plans that were presented before the Board of Zoning Adjustment, and ask for a second, Mr. Blake.
Second.
The motion has been made and seconded, Madam Secretary. Take a roll call, please.
And to clarify, I believe the renderings showing the screens that you're talking about are in Exhibit 31B. Is that what
Yes.
you wanted to include?
Yes, thank you.
Okay. Okay, please respond to the chair's motion to approve the application. Chairman Hill,
Yes.
Vice Chair Blake,
Yes.
Smith,
Yes.
Commissioner Wright.
Yeah.
Staff would report the vote as 3 to 1 to 1 to approve application number 21263 on the motion made by Chairman Hill and seconded by Vice Chair Blake, with Commissioner Wright opposed.
Thank you. All right, everybody. Thank you all for your time today. I hope you guys have a nice evening, and I'll see you next time. We're adjourned. Bye-bye.